The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division's First Department's virtual argument session. I'm going to begin by calling the calendar, so please, everyone, listen carefully. People versus Lakeisha Thomas for the appellant. I'm sorry, this is submitted. Barreto versus the City of New York for the appellant.
Jason Meneses from the Law Office of James Toomey. I'd like to request 5-1. Yes, thank you.
5-1. For the respondent.
Jason Krakauer, Rapelson Levine Law Firm for the respondent, Rebecca Barreto.
4 minutes.
Yes, thank you.
For the respondent, Corp Counsel.
Kevin Osowski for the Corporation Counsel's Office. We also request 4 minutes.
4 minutes.
Thank you.
Genesis H is submitted. Bank of America versus Angel. 2 appeals, both are submitted. People versus Empire Bonding is submitted. Sky Coverage Inc. versus Alwex Inc. for the appellant.
Good afternoon, Your Honor. Matthew Trokenheim from the law firm Goldberg Segal.
6-1.
6-1 is fine. Thank you.
Thank you. For the respondent.
Robert Fass with Goldsmith and Fass.
6-1.
Thank you.
Douglas Elliman versus ETA Realty for the appellant.
Michael Cole, Hanson Chester.
2 minutes, and the respondent is a submission. 558 7th Avenue versus Times Square Photo for the appellant.
Paul Gruber from Bora Goldstein, 4-1, I believe, was allotted.
4-1. For the respondent.
Good afternoon, Your Honor. Gary Fish for the respondent. 4 minutes, please.
4 minutes. People versus Keith Jennings for the appellant.
Good afternoon, Lena Janota on behalf of Keith Jennings.
4-1. For the respondent.
Good afternoon, Franklin Gunther on behalf of the people.
That's 4 minutes. U.S. Sabaki Holdings versus Estes for the appellant.
Good afternoon. Good afternoon, Brian Fisher, Jenner & Block LLP. I'd like to move to have my partner, Ian Heath Gershengorn, as a member of the bars of the Commonwealth of Massachusetts and the District of Columbia, and it was admitted pro hoc vice to this court on December 28, 2020. I'd like to move Mr. Gershengorn so that he may argue this motion.
So I'm going to quote my fellow esteemed justice who's sitting on this panel, Justice Angela Mazzarelli, and that would seem with all of the lawyers in New York that you could find one here. But having said that, I am going to grant the motion. And Mr. Gershengorn, is it? You
Yes.
have 6 and 2 for rebuttal.
Thank you, Your Honor.
For the respondent.
This is Brian Herman from Morgan Lewis on behalf of the respondents NSCCC Acquisition, New State Capital, and New State Management.
4 minutes.
Thank you.
Daniel Tabak from Cohen and Gresser LLP on behalf of the Estes respondents. The Honigman firm does not have lawyers in New York, so I respectfully request that Jeffrey Lamb of the bars of the states of Illinois and Michigan be admitted to conduct the argument.
And the same goes for you. And Mr. Lamb, I will grant the motion and give you 4 minutes.
Thank you, Your Honor.
Konstantopoulos versus Union Mutual for the appellant.
Good afternoon, Craig Blumberg for the appellant.
4-1.
Right.
For the respondent.
Good afternoon, James Stewart for the respondent, 4 minutes.
James, your last name, please.
Stewart, S-T-E-W-A-R-T.
Thank you. 4 minutes. People versus Demel Jennings for the appellant.
Good afternoon, I'm Julie Pasmanathan on behalf of Mr. Jennings.
7 and 2 for the respondent.
Good afternoon, Your Honor. Susan Axelrod for the people. I believe I've been given 7.
7. HM versus the City of New York for the appellant.
Michael Becker from Rutherford and Christie for defendant appellate Leakin Watts and defendant respondent City of New York.
5 and 1. And for the respondent.
Good
This is the plaintiff respondent appellant, Your Honor, Krista Della Carpini for the Miller family. I believe we have 5 and 1.
5 and 1, yes. And for the, I think it's Kelly Wright for the defendant respondent appellant?
Yes, Kelly Wright from Scahill Law Group for Jose Alicea, defendant respondent appellant.
And that's 5 and 1.
Yes, thank you.
Capon and Associates versus Herskowitz for the appellant.
For the appellant, Michael Giordano, McDonald and Adels, we request 5 and 1, Your Honor.
5 and 1. For the respondent.
Good afternoon, Your Honor. Jonathan Lynn from Oved Noved LLP for the defendant's respondents. We request 5 minutes.
5 minutes. Whites versus Bernstein is submitted. PD versus LaCour Gayette.
Alan Friedberg, Wilson Elster on behalf of appellant Montefiore. I believe we have 6 and 2.
That's right. And for the respondent?
Yes, Lawrence Lame for Jonah Grossman. We'll take 4 and 1, please.
Four and 1. And Godlewski versus Park 79th is submitted. MJC Electric versus Hudson Meridian is submitted. Council, please remember, excuse me, as always, that we have your brief, we have the record, and we're fully familiar with the facts of your case. So please go directly to the most important points that you wish to make. And also, as is customary, please don't speak when a justice is speaking. This is particularly important, of course, during our virtual arguments in order to hear one another and for you to hear the question that's being posed. Finally, please keep your mics muted until your case is called, and at that time, only if you're the person speaking. Thank you in advance for your patience and your cooperation. The first case is Rebecca Barreto versus the City of New York.
Good afternoon.
Just a moment before you begin. Thanks. Okay.
May I proceed?
Yes.
May it please the court. Good afternoon, Your Honors. My name is Jason Meneses. I am from the law office of James Toomey, and I represent the appellant Ahern Holtzman. The facts of this case are simple and clear cut. On January 18th,
may I just ask you something straight away, which is why isn't the summary judgment motion in this instance premature, where there hasn't been any discovery on you or anyone else yet?
So, Your Honor, respectfully, I would argue the motion for summary judgment is not premature. In support of the motion for summary judgment, Ahern proffered the affidavit of Mr. James Gratt. He is a project manager and estimator. He had intimate knowledge of the work that was performed by Ahern. His affidavit makes clear.
Did you submit the contract? I know that you did submit an affidavit from him where he says that the contract is not for the sidewalk work. Did you submit the contract? I didn't see that.
I apologize. So we were unable to locate the contract. However, in support of the affidavit, I did annex the drawings, the schematics from Hoffman Architects, which lays out very clearly where the work was to be performed. In that architectural.
Those things those things can change. I mean, you did indicate, I think you attached the architectural design, but there are sometimes adjustments can be made, and you have a permit here that's broad. It's not like the case you cite where it says specifically where the work is going to take place. Shouldn't they have an opportunity to take a look at the contract, to question whether or not the architectural plans, for example, remain the same and do other types of discovery?
So my position is that Mr. Gratt made clear that the work was exclusively performed on the sidewalk 230 feet north of where the incident occurred. There's no evidence that any work was performed anywhere in the roadway. And I do understand the argument that there are broad permits, but the permits are issued for the entire block. But that doesn't necessarily mean that the work encompassed the entire block. The work was limited to a portion of the sidewalk abutting 557 Broadway. None of that work was encompassed in the none of that work took place in the roadway or the crosswalk at the intersection of Mercer and Spring Street. Additionally, Mr. Gratt reviewed the photographs that were proffered by the plaintiff in the course of discovery, and essentially stated very clearly that was not the area where the work was performed, that the condition was not created in the course of any work performed by Ahern. Additionally, with respect to the issue about the permits, the plaintiff herself testified at her 50H that she walked through that crosswalk twice a day for 5 days a week for many weeks. She did not see any construction going on. She didn't see any cones, any barriers, any construction materials. So, I understand that the contract certainly would have been more helpful if we were able to locate it. But I believe that a prima facie showing was certainly made with respect to the fact that none of the work was performed in that area. It was 230 feet away, and in opposition, if essentially boiled down, my point is essentially if there were documents to demonstrate that my client caused or created the condition, the city of New York and its related entities would have been the only parties in the custody and control of any documents to refute Ahern's position that they didn't do any work. A notice of violation would have been issued, a corrective action request would have been issued, a summons, and none of those documents were proffered in opposition, other than an attorney's affirmation stating, we need more discovery. There's nothing to call into question Ahern showing that they didn't perform work in the area.
Thank you.
That's the essence of the argument. I mean, I rely on the remainder of my brief. If you have any questions, I'd be happy to answer them.
Okay, thank you very much. Any further questions from the bench? I don't hear any. Let's go to Mr. Krakauer.
Thank you, Your Honor. May it please the court. The most important point in this is that it is a pre-discovery summary judgment motion. They submitted a self-serving affidavit, which is completely contradicted by the permits that were offered in support. The permits, the scope of the permits is significantly greater than what is in the self-serving affidavit. And I think the most important point is the issue raised in the motion, the appeal, the reply. The defendant states that the permits issued on their own are insufficient to raise a triable issue of fact, and that the respondents failed to proffer any evidence. Well, obviously, we failed to proffer any evidence because this is pre-discovery. We haven't had the chance to go through discovery to get the evidence that we need to submit to properly oppose their motion. They state
counsel says there is no other discovery necessary because they have an affidavit from the project manager who says that the contract was not for the sidewalk, and that their detailed architectural plan says it wasn't for that area where the plaintiff fell. Why isn't that enough?
Well, first of all, the affidavit is self-serving. Second of all, this is their motion for a summary judgment, and they don't produce the contract. I don't understand how they can make a motion for a summary judgment saying that the contract doesn't cover that area of the street without producing the contract. Furthermore, I think Your Honor hit the nail right on the head. Where are the rest of the documents? The scope of plans change throughout the construction project. They rely on only one document. Where's the contract? Where are the work orders? Where are the invoices? Where are the progress photos? This is all information that we would be able to get during discovery if we were allowed to proceed with discovery. So they make a summary judgment motion saying that the contract doesn't encompass the area where plaintiff fell without actually producing the contract, without producing any of the progress photos or work orders or anything other than a self-serving affidavit and one document that's basically the plans before they actually completed the work.
Thank you.
Yes. One last thing is the cases cited by appellant are completely an opposite, as they don't even deal with pre-discovery summary judgment motions. And in those cases, the defendants are actually deposed, which we haven't had the opportunity to do in this case. Thank you.
Thank you. Is it Mr. Osowski? I'm sorry.
That's right, Your Honor. Yeah, thank you. May it please the court, Kevin Osowski on behalf of the city respondents. Supreme Court properly denied Ahern's motion without prejudice and with leave to renew because it was premature while this discovery remained outstanding. And this court has repeatedly found that summary judgment is premature under such circumstances, and that the right thing for a Supreme Court to do is exactly what the court did here, to deny that motion without prejudice and allow renewal of the motion after some discovery. I know the court has examined the record here, and I think the affidavit provided in support of the motion on 176 to 78 of the record demonstrates itself why it's not sufficient. It purports to draw the conclusion that Ahern is not responsible, but is only based on knowledge of the general practice in the documents. It doesn't say anything about firsthand or even secondhand knowledge about what work was actually done at the site. Moreover, it doesn't address the permits or in-person observations, including after Ms. Barreto's counsel raised them in opposition to the motion. Ahern did not take the opportunity to submit a supplemental affidavit in further support of its motion and address why, as it claims now, its work was somewhat narrower than what was permitted by the permits. And my last point is that there's no prejudice to Ahern in denying this motion for summary judgment. As I've said, the Supreme Court's decision explicitly allows Ahern to renew and does so without prejudice. And there's no additional production obligation for Ahern as directly required by the motion. Ahern really just needs to wait until document production is complete and also to sit for a deposition so that the assertions in the affidavit can be examined.
Thank you. Mr. Menezes?
I would like to, just respond. The issue of whether the contract being turned over in connection with the affidavit was never, ever raised in opposition to the motion for summary judgment. That was not a basis of any opposition by either the city entities or the plaintiff. With respect to document discovery, we've turned over everything that Ahern has in its possession. The architectural plans make very clear what occurred, and additionally, the photographs proffered by the plaintiff, which are alleged to depict the actual condition, were reviewed by Mr. Gratt, and he affirmed under oath that it was not created in the course of their work, that their work was not in that area. So the hope that something may come out of the deposition is just it's grasping at straws to hope that further discovery may lead to something to implicate my client, but there's just no evidence there. And with that, I rely on the remainder of my brief.
Thank you. Thank you all.
Thank you.
Thank you, Your Honors.
Sky Coverage Inc. and Marie Bacci versus Alwex Inc.
Yes, Your Honor. Good afternoon.
Good afternoon. Just one moment, please.
Yes, standing by.
Okay, you may begin.
Okay, so good afternoon. May it please the court. My name is Matt Trokenheim. I represent the defendants, appellants, respondents, Alwex Inc., Harvey Wexelman, and Nicholas Ross. The main issue in this appeal is plaintiff's entitlement, or lack thereof, to the equitable remedy of rescission, by which plaintiff hopes to cancel out $300,000 of settlement payment that's overdue and claw back.
Sorry to interrupt you, but they claim that they're entitled to this because of the violation. They say there is a violation of the non-disparagement clause. So with regard to rescission, why your argument is that they're not entitled to rescission, and I'm asking, why aren't they entitled to rescission? Why isn't that an adequate remedy of law where they're talking about damages of reputation and similar issues?
Well, so thank you, Your Honor. The claims they've made in their argument to the motion court and the court here is that the alleged disparagement damaged their business. It damaged their business by causing them to lose money or fail to make money. Those are money damages. That's the definition of an adequate remedy at law. So, plaintiffs may point to say there's some reputational damage, but this is a business dispute. It's not a personal dispute. The basis of their action from the very beginning has been, we've suffered massive amounts of business losses, though they don't submit any evidence of a single lost customer or a single lost business opportunity. And this dovetails right into the requirement that the breach substantially defeat the purpose of the contract. When courts look at what the requirements are for that element, they look at, we have to identify the purpose of the contract, and we have to establish that there's a breach that frustrated it. And in looking at what the purpose was, we go to the transcript of the settlement in the motion court. They explicitly said, this settlement is contingent on a lifting of the TROs. And in their papers, that's on page 75 of the record. And in the papers submitted in the motion court and the papers submitted here, they claim that the violation of non-disparagement frustrated that purpose because it interfered with their business. Well, that again is simply a statement of there being an adequate remedy at law. In order for there to be in order for this to frustrate the purpose of the contract, it has to interfere with their business. If it interferes with their business, there's an adequate remedy of law. There's no scenario where they can establish the entitlement to rescission. And more importantly, they can't restore the status quo through rescission. In exchange for the settlement, 2 TROs were lifted that allowed them to continue unrestrained use of Allex's confidential client information and solicit Allex's clients. As soon as those TROs were lifted, the status quo could never be restored. They've now had 3 years to use that information, solicited hundreds of thousands of dollars of Allex's business, and the cat is out of the proverbial bag. We've also moved on the election of remedies. Plaintiff didn't simply not make their settlement payments. And if they had, Allex would have acted on that immediately and attempted to restore the restrictions. Instead, they made these payments over the course of 18 months, accepted the benefit of the lifted TROs, and now is seeking to say, well, you can't have the benefit of your injunction, but you also can't have your money. And that's what the election of remedies doctrine is for. Non-breaching party can't continue performing and accept the benefit of the other party's performance and seek rescission at the same time. It does an injustice to both parties, I think, in that circumstances. We also moved to convert the dismissal of or the denial of the contempt motion to be with prejudice because there is no clear and unequivocal mandate. There was an injunction that simply said the parties cannot disparage each other. The settlement agreement and the transcript of the settlement also said the parties can't disparage each other. Neither one of those instances define the word disparagement. We've provided multiple dictionary definitions that include an element of falsity. We've cited cases that include an element of falsity, and plaintiffs have provided a dictionary definition that doesn't include falsity. Although
you had 2 grounds that you moved on, right? Yeah. One was procedural and one was substantive.
For the contempt motion?
For the contempt motion.
Yes.
Right? Yeah. And you were granted relief on the contempt, on the procedural aspect.
Correct.
Yeah. So do you,
without prejudice,
do you have standing? I mean, are you aggrieved? Do you have standing to proceed on the substantive, given the fact that you got relief that you asked for?
I believe that we do. The court specifically stated that plaintiffs should renew that motion. They included in their order that the contempt motion.
But the court might have said that, but it's not a directive. It's not an order. They get to determine that.
Well,
so that's sort of not.
I'm sorry.
No.
The court also scheduled a trial of the contempt motion without it having been renewed. I think the court is contemplating dealing with these issues, and they put in their order that plaintiff is entitled to seek rescission as a remedy for contempt, despite the lack of authority under the judiciary law to get an equitable remedy for contempt. So I think we do have standing. I think the court put it at issue. And in order to judiciously and effectively and efficiently deal with this case, it should be decided.
Okay, thank you.
Thank you, Your Honor.
Mr. Held, I believe.
Mr. Fass, actually. Robert
Okay,
Fass,
sorry about that.
with Goldsmith and Fass, it pleased the court. This case turns on an interpretation of a non-disparagement clause. The first thing I'd like to address is whether truth should be a defense in a contract action as opposed to a defamation or commercial disparagement case, both of which are torts. New York courts have been far from clear on this. We submitted Pennsylvania federal courts, which apply Pennsylvania law, which is identical to New York law and contract interpretation. The meaning of the contract can certainly be determined based on contract principles. What was the intent of the parties? What were the circumstances existing at the time the contract was formed? What the plaintiffs, Mark Bakshi and Sky Coverage, were attempting to do is buy their peace and continue with their making a living without interference from the defendants. And as soon as this contract was signed, what happens? There's a whole series of disparaging comments, so-called investigations, police reports that accuse Mr. Bakshi of criminal conduct. And as Your Honor pointed out, that goes to the issue of reputation. Now, it may be that there are some damages that can be recovered. We've also sued for defamation. But is it complete relief? And the answer is no. Damages.
Counsel, don't as Mr. Tockenheim said, don't all of these things, Tockenheim, sorry, I'm sorry.
Tockenheim, Your Honor.
Don't all of these issues really go to the business? It's oh my, the reputation of the business, and so we're not getting the same amount of clients. But all of those things are they not things that can be taken care of with monetary?
Unfortunately, no, Your Honor. When your reputation is destroyed, trying to peg a particular monetary value on that loss is impossible. We know that if he lost a particular client, yes, but how about continuing in the future? People, it's a small industry. Everybody knows everybody in the insurance business in New York, and they're not going to do business with Mr. Bakshi or with Sky, and that can never be recovered, because there are these statements out there that he is guilty of criminal conduct. And that's shameful. And the only way to recover that is to say, no, this kind of conduct should not be permitted. They should not be able to benefit from a very generous settlement number and then flout the directive of the court. With respect to the jury trial issue, since we have both equitable and law claims, Mr. Trockenheim's argument that they must have a jury trial, which can then be used as an advisory opinion on the equitable claims, is simply wrong. The court has discretion whether to try the equitable claims separately and then have a jury trial on the rest of it, and that's what was done. With respect to the contempt, that was denied on procedural grounds. We have not, and the court provided that before the trial we could renew that motion. That has not yet been done. Trial has been adjourned. So there's really nothing to appeal. We don't know what's going to happen on trial of the contempt motion. Although
you have a cross appeal also, right?
Yes.
Why don't you address that?
The basis for that is that there is no denying that by the defendants that disparaging comments were made. What they seek to do is escape their responsibility by saying, well, they were truthful. The whole idea is we shouldn't have to be litigating the truth of these statements. The idea was put an end to this litigation and get on with your business. And the elocution by the judge on 2 occasions made that very clear. This is not an unclear directive.
Okay, let me see if there are any questions from the bench. Any? Okay, thank you. Let's go back to you, Mr. Trokenheim. You're on mute. You're on mute.
Very sorry, I muted after I got off.
That's what we want you to do. It's okay.
Thank you, Your Honor. So I'd like to address the last thing Mr. Fass said first. He said that there's no denying that disparagement took place. We absolutely deny that disparagement took place. There were two buckets of alleged disparagement. One was related to LOX's attempt to pursue an insurance remedy for Mr. Bakchi's theft of money.
What you're saying is that what you said was true. You're not saying you didn't make those statements. You're saying that you believe that they were all based on truth.
I'm not only saying that they were all based on truth. I'm also saying some of them weren't disparaging under any definition of disparaging, but they were also all brought on by Mr. Bakchi's conduct, much of which took place after the settlement. So there were two buckets. One related to the insurance claim.
But didn't you have a waiver of anything, all claims coming up in the past, from the past, in the future?
No.
I mean, wasn't there?
No, Your Honor. It was not a general. It was not a general relief. It was a relief. It was a dismissal with prejudice of this litigation. The settlement agreement contained no release at all. So there was there were other activity that was uncovered in the course of investigating Mr. Bakchi's theft of client information that included theft of money from clients. So that was reported to the insurance carrier, who then, before the litigation started, who then required it be reported to the police in order to obtain the insurance coverage. But then there's the second bucket, which is statements to the carriers related to clients themselves. And those were all made in the context of attempting to retain a client, as we were entitled to do, at times when Mr. Bakchi was submitting broker of record change forms, which we call BORs, without the signatures or authorizations of the clients. So Mr. Bakchi was creating these circumstances where Allwex had to respond. Now, in none of those responses did Allwex say he forged a signature or he committed a crime. That was statements made by the clients themselves. I didn't sign this. Who forged my signature? And they are trying to impute that to Allwex simply for trying to vindicate its rights and protect its clients from Mr. Bakchi's fraud. Okay. So
thank you.
Disparage. Thank you.
Mr. Fass, you have 1 minute.
Thank you, Your Honor. Very quickly, on the interpretation of the contract, I asked the court to keep in mind that a contract should not be rendered meaningless. It should not be considered surplusage. And had there been no contract at all, our clients would have had the right to bring an action for defamation or commercial disparagement as a tort, which we have done. Contract, though, must have added something, or else it's totally meaningless. And that is directly contrary to the rules of contract interpretation. As far as what constitutes disparagement, I think there are statements there that, as he admits, he forged signatures. He stole money from the corporation. It may well be that these things are false, but regardless, they should not have been said. There were other ways of doing this.
Thank you. I think I understand.
Okay, thank you.
Thank you both. Thank you both.
Thank you, Your Honor.
Have a good afternoon, Your Honor.
Thank you. You too. You do the same, Mr. Tokenheim. Douglas Elliman versus ETA Realty.
Michael Cole Hanson Chester for the appellant Douglas Elliman.
Counsel, you have 2 minutes. Okay. Go ahead.
Yeah, and with that 2 minutes, I'll give you 7 basic uncontested facts why, but for the broker, there's no transaction, no deal, the direct proximate link in the terms of Spree Realty as this court has defined what procuring causes. Fact 1, David Feldman, he is the principal of the buyer. He says he was aware of the property. He passed it many times. He knew it was for sale. but can recall no discussions or offers ever made before the intervention of the broker. And that appears in the record page 221 to 223. That's his deposition. The next fact, the broker is given only a 60-day exclusive. That's it. And that was from December 1 to February 1, 2018, extended to February 28. That appears in the record at record page 49. The 60-day provision is paragraph 6. The extension is R52. The next fact, the broker attests that within 2 weeks of getting the exclusive, he submitted a formal written offer by the buyer, Circle F, for $6 million all cash, record page 36. The next fact, joint offer from iCross Capital and Circle F, the very offer I just spoke about in writing, signed by John McInerney of iCross, December 12, 2017, for Circle F R53. Now, the authority for this, for Mr. McInerney signing for Circle F, appears in record page 146, 194, 208. The next fact, Circle F poses a sole offer for $6.4 million within a week of the termination of the brokerage agreement. That appears record page 57. Contracts are sent out within 2 weeks, record page 60. Contracts again sent out in June for $6 million.
If I may, sir, this is Judge Mazzarelli. Wasn't the agreement with the defendant terminated before the transaction was finalized?
Yes, it was definitely terminated before the transaction was finalized, but the standard for being able to, or entitlement to, a brokerage commission pursuant to Spree Realty is whether or not the broker was the proximate link to the transaction. My real point to you is, if you pull out the broker, there is no connection between Circle F, the buyer, and the transaction. He brought them together in a formal offer, which continued nonstop until the property was sold in June of 2018. And Spree says the broker does not have to be there for the final.
Can I ask you something? Because your time is up, but can I just ask you, there has to be, you said approximate cause of the transaction, but there has to be a transaction. And the letter of interest didn't make any offer. There was no offer in there. So if there's no offer, where's the transaction?
The offer was made in December of 2017, a formal offer by Circle F to purchase for $6 million all cash. The actual transaction in June was $6,050,000. It's an unbroken string of events. And if you pull the broker out, you have no link between Circle F and the actual transaction.
Okay, thank you very much, sir.
Thank you.
Thank you. 7th Avenue versus Times Square photo.
Good afternoon. If it please the court, Paul Gruber from Borough Goldstein for the appellant. We ask that the court reinstate the complaint, grant summary judgment against the tenant, and remand the matter with respect to the guarantor. Subsequent to the perfection of the appeal, the tenant vacated the premises. This is a plenary action seeking money damages close to $200,000. It is within the Supreme Court's subject matter jurisdiction to entertain. It is not within the civil court's subject matter jurisdiction to entertain. Certainly, the landlord could have brought a summary proceeding if it wished. It chose not to do so. Justice Bannon's election to dismiss this case because it was a landlord and tenant dispute that should have been heard in civil court is clearly erroneous, and at a minimum, we are entitled to reinstatement of the complaint. With respect to the claim against the tenant, Times Square's properties, the landlord had sought summary judgment in the court below. The merits weren't adduced. Should the court elect to reach them, I would point out Article 85 of the lease at page 105 to 106 of the record is a force majeure clause, and it says very clearly that the owner and tenant shall be excused for the period of delay in performance of any obligation hereunder, except for the payment of the
You know,
minimal.
I read that, excuse me, Mr. Gruber. This is Judge Mazur. I read that force majeure clause, and, you know, if you still have to pay the rent, what's the point of the clause?
That was an issue that should have been brought up at the bargaining table, Your Honor. There are other obligations under the lease too, which could be impacted theoretically.
I understand that, but the main obligation
Yes.
under the lease is money. It's the rent. It's what you gotta pay. And it just seemed to me to be sort of a exercise in futility, that force majeure clause. I'm assuming the tenant was represented by counsel when the lease was drafted, but I don't know.
I don't know either, Your Honor, but this is the lease. This is the lease that we have, and under New York law, it should be enforced in accordance with its terms.
What about some of the governor's executive orders that were issued during this time period? This period we know relates to the lockdown and caused by COVID.
Yes. Under this record, this tenant had to close for a period. It did reopen before this action was commenced, or shortly thereafter, I believe. It did conduct business under the frustration of purpose doctrine. The fact that your profits aren't as what you expected doesn't render the obligations under the lease unenforceable. So I believe that while it's an unfortunate situation, there is an agreement between the parties, and the agreement of the parties is clear. If I can move on to the last issue, which is the guarantor. Again, the issue wasn't addressed directly by the court, given its disposition. The law that the city council had enacted, which precluded a claim against certain individual guarantors of commercial leases, lapsed on March 31st. The council extended it, and it went into, and it was enacted into law a few days ago by virtue of the mayor not signing it. And under the city charter, apparently that means it's law. Our position is a very simple one at this point. The motion should be considered on the merits, and the law doesn't apply simply because if you look at the legislative intention in the earlier versions and the most current version, which is Local Law 50 at paragraphs 6 and 9, it was designed to give a tenant in business a little time to get back on its feet before it has to deal with litigation. Unfortunately, this tenant has vacated, so at this point in time, the statutory purpose doesn't preclude the guarantor from, litigating the claim and defending it with whatever defenses may be available in court. Unless the court has any further questions, I'm resting on my brief.
Thank you. Thank you.
Thank you.
Mr. Fish?
Good afternoon, Your Honors. May it please the court. Contrary to what the Appellate's counsel says, the personal guarantee of respondent Saka was barred by New York City Administrative Code 22-1005. The appellant submitted this in record of appellant at page 30, and in record of appellant at page 4, Justice Band in their January 11, 2021 decision noted that the appellants themselves acknowledged that the only liability of guarantor Raymond Saka was prior to March 7, 2020. Respondent Raymond Saka had the right to rely on existing law. If there was any problem with this law, it was incumbent upon appellants, which they never did, to file a declaratory relief action. In federal court, they claimed there was a Fifth Amendment unconstitutional taking. That's a federal issue, was never addressed. And the mere fact that they may have pled this does not constitute resolving this issue. They should have moved for a stay of the original summary Supreme New York action, moved for federal court to get a declaratory judgment. They probably didn't, because that could have been used not only as a sword, but also as a shield. All these issues were addressed. None of the decisions by Justice Bannon were clearly erroneous. And in fact, Alex Saka, record of appellant, pages 136 to 137, sets forth inadmissible, clear and unequivocal evidence, never contradicted one iota by appellants, that the store was shut down, that there was a commercial frustration of purpose. The appellants never offered even one iota of evidence to contradict thereto. It was incumbent on appellants under CPLR section 3212, the personal knowledge requirement of summary judgment motion, to set forth admissible evidence contrary to Alex Sacca's affidavit. They did not. Record of appellant at page 4, Justice Bannon even referred to this, that appellants failed to offer any evidence in contravention of Alex Sacca's commercial frustration of purpose defense. They have waived the right. This is merely a collateral attack on a good decision that should be given stare decisis, res judicata effect. You should, with all due respect, send appellant home without any relief whatsoever.
Thank you. Mr. Gruber, you have 1 minute. You're muted. You're muted. You're muted.
I'm sorry, Your Honor. I would ask the court to look at Justice Bannon's decisions. What Mr. Fish said, it says, doesn't really say that. As for the so-called factual issue, we didn't dispute that the store was closed. The governor ordered that it closed. We relied upon the documentary evidence, which counsel does not dispute because he cannot dispute with respect to the force majeure clause. And as for the guarantor, this argument that we had to go to federal court first to resolve the constitutional issue, this Supreme Court is of unlimited jurisdiction. It could have entertained that claim. We raised it there. It was a bona fide place to raise it. And I'll go one step further at this point. Given the fact that the statute upon which the respondents based their defense on the guarantee has changed, and the legislative intent of that is clear, and they're no longer a tenant, then the guarantor should litigate the claim, or at best it be stayed. There was no reason to dismiss it. The city law does not purport to absolve the guarantor of liability. It just addresses when you can go after the pursue your claim.
Thank you.
Unless there's anything else, thank you very much.
Thank you both. People versus Keith Jennings.
Good afternoon, Your Honors. May it please the court. Lena Janota on behalf of appellant Keith Jennings. Mr. Jennings is currently serving a 5-year sentence followed by 3 years of post-release supervision for 2 crimes he committed when he was 18 years old. We're asking the court, in the interest of justice, to reduce Mr. Jennings' sentence of post-release supervision from 3 years to the statutory minimum of 2.5. First, because it was the court's intention below to apply the minimum sentence, and second, because the sentence is excessive. So the court's exact language below was, quote, minimum offer 5 years jail, 3 years post-release supervision, waiver of appeal, end quote. And as neither
This is a 6-month difference?
Yes, Your Honor. And as neither the court nor the people articulated any reason for why Mr. Jennings should receive above the minimum, it's reasonable to infer the court simply misstated the minimum by 6 months. However, if this court declines to find that the lower court misstated the minimum, it is still excessive and warrants a reduction based on Mr. Jennings' age and his lack of criminal history.
Thank you. Any further questions from the bench? Mr. Gunther?
Thank you, Your Honors. Franklin Gunther on behalf of the people. Defendant's sentence was not excessive in this case. The court should consider first the severity
Given
of
the
these
court's
two.
statements, didn't it appear on the record that he intended to give the minimum, which is just a 6-month difference? I mean, on this case, he gave the minimum on the prison term, which he could have increased, and seems he intended to give the minimum on the PRS.
Well, Your Honor, as defense counsel noted, the court used the word minimum and then said the word offer. There was never any indication that the court intended to give the statutory minimum simply by using that word. I'd also note that neither of the parties raised an objection to this offer, and in fact, it was noted multiple times, both at sentencing and at the plea, that it was the work of defense counsel to secure this agreement. I'd also note that although this is not in the record on appeal, as far as the people are aware, defendant's co-defendant in this case received the exact same sentence, both for 5 years of the statutory minimum as a term of imprisonment and 3 years post-release supervision. So the court's statement taken in context, there's simply no evidence that the court intended to offer the statutory minimum. And again, I would just go back to the severity of these cases. One involved the defendant showing what appeared to be a firearm, and the other resulted in one of the complaining witnesses being stabbed and requiring stitches. And so these certainly weren't, the least dangerous types of these cases. And as I noted before, this is precisely what defendant and his attorney bargained for, and considering that the sentencing exposure the defendant faced if he actually proceeded to trial, given that these were two separate transactions and that there were 4 additional counts, it was noted multiple times at both proceedings that this was an eminently fair sentence given the circumstances and the sentencing exposure that he faced. Thank you very much.
Ms. Genoda, back to you.
Briefly in rebuttal, Your Honors. Mr. Jennings essentially went from being in the 11th grade at Grant Street Campus High School to serving 5 years in an adult facility, even under the minimum term of post-release supervision, 2.5 years. That's a very significant amount of time, especially for a young person. And while we're not by any means underscoring the violence of these crimes, the minimum is warranted here, and anything above the minimum, including for post-release supervision, is excessive. And for those reasons, we ask that the court exercise its interest of justice discretion to reduce to the minimum sentence. Thank you.
Thank you. Thank you both. U.S. Tsubaki Holdings versus Estes.
Good afternoon, Your Honors, and may it please the court. Ian Gershengorn on behalf of U.S. Tsubaki Holdings, the purchaser here. The trial court held that my client's fraud claims arising from the purchase of defendant's business are legally barred. That decision cannot stand for 2 basic reasons. First, this court's decision in Wiley v. ITT Corp. compels reversal. Under Wiley, which 2 members of today's panel joined, fraud claims can proceed when they are based on fraudulent misrepresentations of present fact contained in a contractual warranty. That is the situation here. We have alleged misrepresentations of present fact, not insincere promises of future performance. Under Wiley, our claims can proceed. Second, the terms of the contract confirm what Wiley makes clear. We specifically negotiated for language in the contract that reserved our right to sue for fraud if the reps and warranties were fraudulent. We're entitled to the benefit of that bargain. Defendants contend that this court should overlook the trial court's legal error by holding that our pleading below was deficient. That argument likewise fails for 2 reasons. First, there is no pleading deficiency. The pleadings amply describe how each of the named defendants helped to manage, to legitimize, and then to sell a business whose very method of operation was fraud. The complaint sets forth the fraudulent reps and warranties in detail, and it alleges facts that give rise to a reasonable inference of scienter for all of the named defendants. Second, and regardless, there will be future proceedings in the trial court. As a matter of judicial economy, the court should decide the fraud question once and for all to guide the course of these proceedings. So let me turn to the fraud and contract issue. The main point here, Your Honor, is that both Wiley and GoSmile have resolved the main issue here. Recall that in Weil, there was a specific warranty that there were no pending audits. That's exactly the warranty, one of the warranties we have here. And the court said that could go forward. And the same was true for GoSmile, which had a representation that the parties had not breached, the defendant had not breached a non-compete in violation of recital 7 of one of the warranties. And what the court said was, because these are misrepresentations of present fact, they can go forward. Now, the other side's argument is that for the fraud to be actionable, the warranty has to be outside the 4 corners of the agreement. But that's exactly what the dissent argued in Weil and what the majority rejected, which was that the guarantee had to be within the 4 corners of the document. The contract claim, the contract reinforces, of course, what the parties, what the law otherwise requires, because over and again, there were exceptions, except in the case of fraud, except in the case of fraud, and except in cases arising from fraud. Now, the reason for that, of course, is this court's decision in Centro. And what Centro said was that if you want to preserve your fraud claims, the way you do it is to obtain reps and warranties, and then to reserve the fraud claim, have a fraud carve out. And that's exactly what happened in Go Smile, and that's exactly what happened here. So pivoting to the pleading issue, if I might, I want to start with a couple of quick legal points. The first is it is clear under this court's case law and under the Court of Appeals case law that non-signatories can be liable. You can be liable in fraud even if you didn't actually utter the statements. And that's what Pluderman made clear and DDJ makes clear. The second point is that private equity firms can be liable for the fraud of the companies they own when they provide a legitimacy to the transaction. That, again, is DDJ Management, the Court of Appeals decision, where the court allowed the claims to proceed against Roan Group and against Quilvest, which were the private equity owners, not the folks who made the statement in the contract, not the people who made the warranties in the contract. Here, of course, it's the same situation. We have not a single decisive event, and we don't have a company the size of IBM. What we have is a series, what this court called in Loralee, a series of interrelated events, which as a whole show the entire fraudulent scheme. These were key players, and they were integrally involved. How are they involved? Well, on the New State side, New State Acquisition had voting control of the company, had the right to appoint 3 of the 5 directors, and acted as seller representative. New State Capital touted in a press release when it purchased the company its operational expertise, that it had complete alignment with management, that had partnership with management to build the company. And then at the sale, it bragged about how we worked closely with Central Conveyor Management to make this happen. And New State Management managed the company, not as a passive manager, but in a situation in which they got 5% of earnings for their management. And they got a 7-figure bonus when the company was sold. These are New State entities that are deeply involved in the management of the company and vouching for the company and telling potential buyers, we're involved in the management. What about the Estes defendants? Well, the Estes defendants say somehow that we haven't pled with specific particularity. There is no doubt at all there was a pending audit in Canada. We're as specific as we could about that, and that violates a warranty, one of the warranties. There is no doubt there was a separate contract with Larry Estes. That violates what that was not disclosed.
But when they talk about particularity, obviously they're talking about each individual, as to each individual. Is that necessary?
I don't think it is, Your Honor, in this sense. In a small, closely held business, it is what the court's cases require is that it be a reasonable inference from the fact that each of the individuals had the requisite knowledge. And we think in a situation in which we've alleged pervasive fraud, in which a small business, in this case, an Estes family started out, that they have that creates the kind of requisite interest. And that's what indeed this court's cases have said. When you can, when the level of involvement and knowledge is such that it's a reasonable inference, the case can go forward. And we think that the case fits squarely within this court's case law on that ground. And so, in a situation in which we have alleged the kind of company-wide fraud, where we say there was fraud in the way they got their customers, there's fraud in the way they paid their employees, and fraud in the way they kept their books, it's a reasonable inference in a small company that the knowledge is sufficient. And
thank
remember,
you. You have some rebuttal time. Thank you.
Thank you, Your Honor.
Mr. Herman?
Good afternoon, Your Honor, and may it please the court. I'd like to focus on a couple of issues. First of all, we represent New State Capital Partners, New State Management, and NSCCC Acquisition LLC, all of which are separate legal entities, and none of which are the company that was sold. One of those entities, NSCCC, was a partial owner of the company, but it was not operating the company on a daily basis. Now, Mr. Gershengorn, his client has alleged 2 different types of fraud here. The first type of fraud that they allege is that there were statements made during the due diligence process which were false. And the second type of fraud that they allege is that the reps and warranties in the agreement itself were false. And we submit that those claims fail for multiple reasons, as the trial court found. And the first one I'd like to start with is the particularity issue. Now, Mr. Gershengorn states that he's made lots of different allegations. If you look at the allegations, you'll see that there are allegations of wrongdoing with respect to the day-to-day operation of the company, such as issues with timesheets and credit cards and customer relations. And the plaintiffs repeatedly state defendants committed fraud. They lump everybody together and say defendants committed fraud. Many of the allegations that have anything to do with my client talk about information and belief. There is no allegation anywhere in the complaint that my client was involved in any of the alleged misconduct with respect to speaking to customers or with respect to timesheets or with respect to expense reports. And in fact, there's no allegation that my clients were aware of any of those facts. It's all in this notion that my clients were, had an interest in the company and they were, quote unquote, working closely with management. That's the description Mr. Gershengorn gave. But there's no allegations in the complaint that my clients knew of anything. And unlike a lot of the cases that Mr. Gershengorn is citing, in this instance, the plaintiffs have owned the company for years. The transaction closed years ago. They've had full access to all of the company's records. They've rummaged through the documents. They've interviewed the employees. And even through all of that, they've never been able to allege anything that any of my clients actually did, other than one of the clients owning an interest in the company and the other having an independent contractor management agreement with the company. And it's very important from my perspective that if you're going to allege fraud, you should allege it with particularity with respect to each of these entities and explain what each of these entities did wrong.
Yeah, but they're saying at this point, I'm sorry, they're saying obviously at this point, this knowledge is within the company. They have more knowledge of this than anybody else. I mean, they've alleged a scheme, and they've been very particular, I'd say, about what the scheme is, very clear about what the scheme is. And they're saying that for the rest of it, isn't it enough at this stage of the game? For the rest of it, shouldn't they be allowed to proceed? And then they can discover whether or not it's within your knowledge.
Well, Your Honor, this is an instance where they have inherited all of the records for the company. They bought the company, they have the records, and to the extent that there are theoretically records of fraud, those are within their possession. They have every single email the company ever sent to my clients, and to the extent that there was some indication in those emails that my clients were engaged in issues with respect to timesheets or missed billings or expense account abuse, they have those records. And that is the exact opposite of the Pluterman decision, right? Pluterman focused on a situation in which and that's the case they rely upon in its progeny, focused on a situation where you had an outsider with no access to any information about the company. That's the exact opposite of this scenario here.
Counsel, there were no records documenting the paying in cash. There would be no records of that. So without discovery and putting people in a chair to ask them questions during an EBT, how else are they to get that information?
Your Honor,
that would not be information contained in documents.
Your Honor, respectfully, they actually made the allegations in the complaint that happened, and they pinned that allegation on the conduct of the day-to-day managers of the company. My point, and so obviously they have some basis for alleging that fraud vis-a-vis the individual defendants who were operating the company. And my point is, it is critical that we identify the parties at issue. So if you take New State Capital Partners, for example, which is named as a defendant, it did not own the company, it did not sell the company, it did not make reps and warranties in connection with the transaction. And each of these individual defendants should be looked at differently. And the final point that I'd like to make, Your Honor, is that you have to look at the agreement that was signed in toto. And this agreement contains in it an express provision where counsel—
I'm glad that you said that. So why should the carve out for fraud cause of action be ignored? Based on your arguments, that language is meaningless in this contract then.
I'm not suggesting at all that it's meaningless. What I'm suggesting is two things. First of all, there is a provision in the contract which precludes reliance on any statements made in due diligence. So to the extent that there are claims with respect to false statements made in due diligence, those claims have to be carved out based on that exclusion. That is clear law from the Dannon Realty case from 1959 that says if a party agrees not to rely upon something, they can't claim reliance. So that takes care of the claims with respect to the due diligence materials. With respect to the contract itself, to the extent the court is willing to entertain.
Again, due diligence, I think applies when there are actual documents that one can discover with quote unquote due diligence if you have access to those documents. Documents that are in the control or the lack of documents for what can arguably be described as criminal behavior, one would not expect to find a paper trail of criminal behavior.
Your Honor, my point on that is simply that to the extent that they are trying to articulate a claim with respect to the pre-documentation process, they have disclaimed total reliance upon that information, and that's in section 4.26. They said, we will not rely upon any information provided in the due diligence process. And under the Dannon Realty case, a sophisticated company is not allowed to disclaim reliance and then later claim reliance. So
thank you.
I think that addresses the fraud with respect to the statements not in the contract. And with respect to the statements in the contract.
Counsel, if you could just take the next 15 seconds to finish your sentence, because I've given you extra time.
I appreciate that. All I was going to say is with respect to the statements that are not in, that are in the contract, to the extent that the court were to entertain those claims and allow those to proceed because the court determines they're non-duplicative, it should give strong consideration to the fact that the allegations, there are no allegations about the contract with respect to New State Capital Partners and New State Management. The only defendant party to the contract that made the reps and warranties in the contract is NSCCC. Thank you.
Thank you. Now, Mr. Lamb.
Yes, Your Honor. Jeff Lamb, may it please the court, Your Honor. Good afternoon. Jeff Lamb from the Honeyman Law Firm for the appellees, the Estes defendants. This is a buyer's remorse case, Your Honor, related to USTH's acquisition of Central Conveyor. USTH.
That may be true, but it's not about the contract. It's about dealing with potential people on the other side who are less than honorable. And I mean, like I said, the allegations here are criminal.
That, Your Honor, if I can pick up exactly on that point, because the allegations in this amended complaint are plainly deficient. Over and over, they plead generalities on information and belief about the defendants generally, or the Estes defendants.
What is
generally.
general about there being an audit by Canada?
Yes,
what's general
yes,
about that?
That's a great example, Your Honor. They do raise this issue of the Canadian audit, which has subsequently been resolved with the finding of no wrongdoing. So to the extent that
subsequent doesn't matter, and you and I both know that. And the case of Weil addressed exactly that.
Yes, Your Honor.
And there the defendants conceded that failure to disclose an ongoing audit is a misrepresentation of present fact.
Yes, Your Honor. And if the complaint were limited to just this Canadian audit, I think we'd have a different argument and the case would already be over. But here,
so you're saying we should ignore the Canadian audit aspect of it?
Yeah, Your Honor, I think the gravamen of the plaintiff's complaint are these allegations, these very generically pled allegations related to supposed bribery scheme and the supposed conduct, misconduct related to the employees. Pardon me, Your Honor?
How are those allegations generic? And isn't this a motion to dismiss on which we're supposed to give the plaintiff the benefit of every inference?
Yes, Your Honor. It's generic because you can't plead a fraud claim predicated on bribery where you don't identify any individual or entity that was bribed. You don't identify any individual or entity that committed bribery. You don't identify a date of a payment or what that payment secured. All you do is say the defendants bribed unnamed customers to secure unnamed business. And they say it over and over and over again for scores of paragraphs and trade volume for specifics over and over again. And that's precisely what Facebook and MP Cool and even DDJ say you can't do, Your Honor. You have to identify the specifics of the fraud. Who was bribed? When? For what? What employees were paid with the supposed cash option? Goodness gracious, Your Honors, you've referred to it as an illegal scheme, but they haven't cited a single law, rule, or regulation that was violated. They just say this was illegal, but then they don't identify any of the employees who were paid. They don't identify anyone who actually approved these supposedly illicit payments. They just say they're all liable for it because they all managed the company and they were all related by blood or marriage. And that's not permissible. That's precisely the type of pleading that MP Cool says you can't do. You have to identify who knew. It isn't enough just to say you were an insider and you're closely related to these other defendants, therefore you're liable for knowledge. You have to specify the knowledge, and they don't do it. They don't do it over and over and over again. Instead, they fall back on general pleading. They rely on Pluteman and Allenby to try to save these claims, but their case is so different from those cases. In Pluteman, the plaintiff actually identified the fraudulent transaction document, the defective transaction document. They said, it's this document and you knew about this. There's no similarly specific allegation here. In Allenby, the plaintiffs identified 5 different fraudulent transactions, and they even gave the dates and times of one of those transactions. There's no similarly specific allegation here. There's just boilerplate generic pleading about knowledge and intent over and over and over again. And that's why, Your Honors, under MC Cool and under Facebook, these claims are defectively pled. And it's not going to get better. This is not a case where the defendants have all of the information and the plaintiffs don't have it. The plaintiff here conducted a year of due diligence before they bought the company. Then they took possession of all of the company's books and records and all of the Estes defendants' emails.
Again, counsel, if there's payments being done underneath the table, there is no record of that. And the only way, counsel, the only way you can even begin to try to ascertain that is through discovery.
Your Honor, I'm going to politely disagree. They've had access to the employees for over a year who supposedly received these illicit payments.
Right, and employees
identify a
at
single
risk
one.
of being fired, right?
Your Honor, I submit they fired plenty of people and they could identify a single employee if they had any information. They don't have the specifics. We called them out on this 2 years ago. They've attempted to file 2 amended complaints since then, and they still haven't identified a single specific employee who received this supposed cash option or a single date or time or amount of a payment. Nor have they identified how it's actually illegal. They just say it's illegal. They don't say you violated this rule, this regulation, this statute. They just say it's illegal. That's not pleading specific
paying
to the
an
fraud.
employee off the books is not illegal.
They're
if
not
that
saying,
is true, if that fact is true, you are suggesting that that's not illegal?
they're not paying them off the books, Your Honor. They're paying them cash without paying.
If you pay cash and don't add that to the tally of that employee's income, that is not legal.
That's not correct, Your Honor. They're not saying they didn't add it to the tally of the employee's income. They're saying that it didn't get counted.
They didn't do that at all, right?
They said that they didn't credit it for the purpose of paying union dues, Your Honor. That's what the argument is. And they don't say anywhere that that's a violation of a rule or regulation. They just bandy it as illegal and then say the defendants engaged in it without identifying any of the specifics. And
well, that's to avoid paying into the retirement funds, into the pension funds, because it reduces the amount that is allocated to the particular employee. That has a very wide-ranging effect, not to include all the payments to the employee in their salary.
Yes, Your Honor, it could be a serious allegation if, again, they could identify a single employee for whom this occurred. And they've had the books and records for over 3 years now, and they still can't do it. Thank you, Your Honor.
Thank you, counsel. Mr. I'm sorry, Gershengorn?
Yes, Your Honor, just a couple of quick points. First, the counsel for New State has it wrong and Justice Renwick has it correct. The fact that we have the documents doesn't help us to prove the knowledge of the New State defendants, which is what we say we have sufficient allegations to allege.
What was your client doing for a year? What kind of due diligence were they doing for a year before this transaction took place?
So, Your Honor, part of the answer, Your Honor, is that we didn't uncover it for the reasons that Justice Manzanet said, which is that this was done in cash. There aren't deep books. But what we did, Your Honor, which is really important, is that whatever level of due diligence we did, we insisted on reps and warranties, and we insisted on carving out fraud. So what we did was exactly what this court in Centro said we should be doing. Now, of course, so that's the main thing. And the activities of the new state companies in terms of the kinds of management they were involved in, it easily gives rise to a reasonable inference of scienter. They tell the world they're joined at the hip with the management. But then when we come in, they say, we never heard of these guys before. Like, that is not a reasonable inference in the complaint. The same idea with the sort of idea that this is buyer's remorse. With respect on a motion to dismiss, that is not a serious claim. They may believe it's buyer's remorse. They'll have the attempt to prove it after discovery. Justice Manzanet, you're exactly right on the fraud cause of action. Their approach would read the centro language that we negotiated for completely out of the picture. And then the other point is the idea that the problem with our complaint is that we didn't allege that a cash option or kickbacks to our principal customers were somehow not unlawful when it was to engage in avoiding pension obligations and to get bids that we would not otherwise have gotten on the merits, or not we, but our predecessors have gotten on the merits. That's the problem with the complaint. That's hard to take seriously. And then my final point, Your Honor, is that when you read their two briefs, you read the Estes defendant saying, oh, it was the new state people who were doing all the management. You say the new state people saying, oh, we're just the private equity guys. We don't know who's doing the management. In fact, that's exactly our allegations control, though, not their pointing fingers at each other. And we should be allowed to go forward with our claims to get the discovery to back our allegations, which are sufficient, and our fraud claim should be allowed to proceed. Thank you.
Thank you. Thank you. Thank all of you. Oladesis Konstantinopoulos versus Union Mutual Fire Insurance Company.
Good afternoon, Your Honors. My name is Craig Blumberg. May it please the court, I represent the plaintiff appellant. This appeal arises out of a fire loss that occurred on March 3rd, 2017. Plaintiff appellant submitted a claim under his insurance policy, which was ultimately denied by the insurance company, claiming that the policy would be rescinded due to material misrepresentations in the application.
Counsel, the defense says that they did not, that your client didn't report that there was a basement department. Wasn't that part of the online questioning, that you had to report whether you had a basement apartment? I think your client indicated no. Whether or not there were any eviction proceedings, I believe your client answered no, specifically to those kinds of questions.
Yes, that's correct. And the question in the application, which is always completed by the broker, asks how many units are in the building. And yes, there was a basement apartment. It wasn't being used, as far as he knew, until he found out that somebody had basically squatted there, his super. But the main issues for both of those.
But the question was whether it existed, not whether it was being used.
I understand that. And that's why my main argument has to do with materiality, because regardless of whatever misrepresentation may or may not have been made in an application, the materiality is really the most important part as far as we can see. When it comes to materiality of the other unit, when you have an insurance policy that has a 2-unit or a 3-unit, that's something different. In this particular insurance policy and the premiums that would be paid on a 3-unit or a 4-unit, there is testimony and there is no issue that on the property section of the premium, the policy is the premium is calculated based on property section and the liability section. And this claim is under the property section, but the premium on the property section would have been exactly the same, whether it was a 3-unit or a 4-unit. So it's clearly, regardless of a misrepresentation as to the number of units, it was not material. They would have issued the policy, and the policy on the property section would have been for the exact same premium. And that's the testimony. And I'll point out that there has been no offer of any evidence by defendant that as to what the premium was, what it would have been had they known these facts. They just take what they see and say it's a misrepresentation and the premium would have been different, but they don't offer any evidence as to what the premium would have been and how it would have been different. And they are required to do that. And any question as to materiality is a question of fact that can only be decided by a jury. It cannot be just that a an underwriter or somebody from the insurance company comes in and writes an affidavit saying, well, had we known that the premium would have been different. They offered no evidence whatsoever that the premium would have been different, because it would not have. And the argument that the liability side would have been different is completely immaterial in this, on that issue itself. On the question of the eviction proceedings, yes, there was somebody living in the basement. They shouldn't have been there, and he was being evicted. He was not a tenant. And getting past that, we go to the materiality. And again, in the underwriting guidelines, which defendant offers as proof of materiality, there is a catch-all phrase, and let me find exactly what that phrase was. The catch-all phrase in the underwriting guidelines was risks answering affirmatively to any preliminary application questions listed on the Round Hill Express website from time to time. I don't even know what that means. The Round Hill Express website, they are asking this court to find as a matter of law that because they have that sentence written in their underwriting guidelines, that they would not have issued this policy. And it very simply.
If I may just ask you a question, just to clarify a fact to me. Did they investigate the property prior to the issuance of the policy?
Yes, Union Mutual always does inspections beforehand. And generally, from what I've learned over the years.
Record? Were they given access to the premises?
Well, I would have made that argument if they had gotten inside, but there's no real proof that they had gotten inside to see that there was an apartment. But they did do an inspection.
Mailboxes, that there were 4 mailboxes after the fire. Are those on the outside or the inside?
I believe they're on the outside. So
any further questions from the panel?
Well, yeah, if I could just finish with the last.
Counsel, I've already given you some extra time. Why don't you finish on rebuttal? Mr. Stewart?
You're muted.
Mr. Stewart?
I apologize, Your Honor. Can you hear me?
Okay.
Good afternoon, Your Honor. James Stewart for the respondent. Let me address the materiality argument that the appellant has just made. As set forth in the papers very clearly, the third-party administrator went back and figured out that if the true information had been given, the premium would have been 15% higher. 15% is material. Matter of fact, there's an insurance company out there that laid its entire business plan upon 15% savings. There could be no question that a 15% difference premium is material. And that's not disputed.
I'm confused, if I just may follow up on something I was asking opposing counsel. Much is made by you about the fact that there were 4 mailboxes outside the premises that could be seen after the fire. Now, if your inspector, your visited the premises prior and was able to investigate the exterior of the building, presumably those mailboxes were visible at that time.
You're presuming that. There's no evidence whatsoever they were available. They were visible. Also, we couldn't get into the building.
Well, they were visible after the fire.
Yes, there were 4 mailboxes after the fire. There was no information as to one of those 2 mailboxes or 3 mailboxes had been open for one tenant or multiple tenants.
Wait, but they weren't. The question is, were they on the outside after the fire? And the answer is, you're saying they were.
I'm not sure if they were inside the hallway or outside. There's been no testimony or evidence issued on that point. They could have been inside a locked hallway. I can tell you that as to the inspection, they only inspected the sidewalk. They never got inside the building. They were never granted access. And there's been no evidence or any claim by the appellant that these mailboxes were outside the building. Now, as to the claim of this gentleman not being a tenant, it's very important to keep in mind that for more than a year before the application was submitted, the appellant was aware that the person was residing there. And matter of fact, he gave him keys to the premises. Giving keys.
Well, he would have had the keys anyway, counsel. He was the superintendent, for God's sake. So he had the keys for that building and any other building that this plaintiff owned.
I understand that, but this is not coming as some surprise.
So that's not an argument that carries any weight. As a superintendent, he would have had the keys. So what?
Okay. Well, he was residing in the downstairs illegal basement apartment for many months before the appellant brought an eviction proceeding. And when you combine that knowledge with the fact that he gave him the keys and didn't ask for the keys back, never called the police, never tried to have him thrown out for being a trespasser, it's an acknowledgement that he was a tenant. Matter of fact, he went to landlord-tenant court to evict him. He didn't call the police and say, get this trespasser off my property. He acknowledged he was a tenant. But even if he wasn't a tenant, if you look at the language, the policy says the following. 1, you must
He
advise.
didn't acknowledge he was a tenant. He never acknowledged he was a tenant. He said, I took him to court in order to get him out because he was squatting in the basement.
Well, he allowed them to stay there squatting for several months before he brought a proceeding.
I think what happened was he said that he gave him the keys because he was the super, and then found out that he was living there. He didn't realize it. When he found out, he started the proceeding. Once a person is squatting for over 30 days, you have to bring a proceeding. You can't just illegally lock them out or kick them out. So I don't think that goes to whether or not he accepted him as a tenant. But why don't you move on, because your time's almost up.
Let me go to the language of the question at issue. The language of the question issue says the following. It says, you must advise us of all landlord-tenant disputes and any eviction proceedings. Under simple contract law, you have to give all of those words meaning. If there's a landlord-tenant dispute, that would include a landlord-tenant eviction proceeding. So the separate terminology or eviction proceedings stands on its own, whether there is a landlord-tenant relationship or not. It's undisputed here that the appellant did not give notice of that. It's undisputed here that the appellant was aware of the guy being there. He had brought an eviction proceeding. Now, the materiality of that is very simple. You have an additional person residing at the premises, and there's no reason why an insurance company should be forced to buy into a lawsuit. Most reasonable people do not want to issue contracts or get involved in the middle of a proceeding. So there's certainly a material aspect as why the insurance company will not issue the policy. One last thing really briefly. Counsel made a big point about the fact that there has been no additional premium for the property side of the policy. Whether that's true or not, you can't split up the policy. This insurance company does not issue standing alone property insurance. It only issues policies involving both property and liability. So it would not have issued at any time a policy covering only the property without the liability aspect.
Thank you,
Your Honor.
Yep. Mr. Bloomberg, we're back to you.
Yes, let me just follow up with a couple of things. I think what you can tell from the argument is the question of materiality is simply counsel and their clients saying, we wouldn't have done this had we known this. And in order to prove materiality, as a matter of law, they have not offered anything that would support their claim. To say the premium would have been 15% higher, that's just what he says. There's been no documents or calculations or anything showing that the premium would have been higher because it would not have been higher. And when it comes to the eviction proceedings, there is nothing in the underwriting guidelines that says if there's an eviction proceeding of any kind, we wouldn't have issued this policy, because they would have. To say that there's one eviction proceeding in the building, they're not going to insure this property, they come in after a loss and try and fit these things into these holes to prove materiality. But the argument, my final point is very simply, they have not offered anything to prove as a matter of law that anything that they're claiming was material, and materiality is a question for a jury to decide. It is not a question of law, especially given that they've offered nothing in the underwriting guidelines to support their argument. Thank you.
Thank you. People versus DeMille Jennings.
Good afternoon. May it please the court. Anjali Padmanathan on behalf of Mr. Jennings. Your Honors, I'd like to turn to the lower court's error in admitting Mr. Jennings' Riker's call into evidence. We submit that Mr. Jennings' right to equal protection under the law was violated by the prosecution.
So, counsel, didn't the Court of Appeals in the Diaz case state that once an inmate is implicitly consents to the circumstances that he's not supposed to, that they're going to be taped, that he doesn't maintain a reasonable expectation of privacy? And there was a witness, obviously, who said there are multiple statements, signs everywhere that there's no expectation of privacy, that calls it not private.
Your Honor, the issue here is not of privacy. The issue here is a person's fundamental right to prepare their defense for trial. And the equal protection claim here is that they're similarly situated defendants.
So you don't think the Diaz case is applicable?
We're not speaking on consent, Your Honor. No, I don't think it's applicable, because what we're discussing really is how a prosecutor's office, how a government agency treats pretrial defendants. Right now, we have pretrial defendants.
So is a pretrial defendant a protected class?
A pretrial defendant is a similarly situated person as a pretrial defendant who's incarcerated is a similarly situated person as one who is not incarcerated, but they both have a fundamental right to the Sixth Amendment right to prepare defense for trial. And while being a pretrial defendant on its own doesn't make you a suspected class, they are similarly situated civilians who are, some of them based on an arbitrary distinction, their fundamental right is being impinged upon by the government. And
but aren't there security concerns and safety concerns with respect to incarcerated individuals that the facility has the obligation to be careful about, to ensure the security of the entire facility? And doesn't the recording of the phone call relate to that obligation?
DOC's recording of the phone call does, Your Honor. The fact that Department of Corrections has a safety and security mandate over the people that are in its facility is not contested here. And that policy has been litigated already by, the courts of the state up into the Court of Appeals. We're not contesting that. The issue here is whether a prosecutor's office, which is not related in any way, is a wholly separate agency from Department of Corrections, has any grounds to harvest all of those recordings, because the prosecutor's office doesn't have the same obligations to maintain.
Well, it's evidence. It contains evidence of the defendant's statements or the individual's statements on those calls can be evidence in proceedings.
Your Honor, those are two separate things, right? One is about safety and security of a facility. That is why DOCS has been able to, their policy of recording inmates' phone calls has been permissible because of safety and security issues. Just listening in to a person's phone calls, no matter what they are, without any basis to assume that a safety or security issue is happening or a future crime is being committed, there's no authority for the prosecution to do that to just one part of the population. Ultimately, no government agency can do that without any wiretapping order, without any judicial oversight, if a person is not detained. The only difference here is that these people are detained. And people like Mr. Jennings who are detained.
They're also put on notice that their statements are being recorded. So it's not like these recordings are happening surreptitiously. They are told. There's a sign in front of every single phone.
And that's not contested, Your Honor. This has nothing to do with what Mr. Jennings or other incarcerated people know. This is about the Equal Protection Clause. It's what the government is doing, what a government is allowed to do to similarly situated people. Why can a government official, a prosecutor, overhear all the conversation?
So you're saying every single group of similarly situated people can contest the action of any government action just on the basis that all of us in this group are being impacted in the same way to anything?
A fundamental right, Your Honor, a fundamental constitutional
fundamental right to make a phone call?
No, Your Honor, fundamental right.
What's the fundamental right that we're talking about here?
The fundamental right to prepare for trial. Of course, a person.
Well, he's not preparing for trial with a lay witness. Calls that are actually for preparation for trial, calls with counsel are not recorded. So your argument doesn't hold water in terms of what actually happens.
Your Honor, that's not true. First of all, the fact of the matter is a defendant preparing for trial doesn't only prepare by talking to their attorney. A defendant, as I've said,
knowing that the being told, having advance warning that the calls are being taped, I think that if you're thinking you have a witness, you talk to your attorney and ask your attorney to interview the witness. That would be the way it would work. Right? You wouldn't want then the witness to be able to say what you told them and everything else. So that really would not be the most effective way.
Your Honor, that's in one very narrow aspect of looking at someone preparing for trial. But there's the concept of talking to confidants, speaking to family members, speaking to loved ones, speaking to people who may have facts. The defendant is the person that has most of that knowledge. And I think a good analogy to bring
counsel, but you and I both know that defense attorneys counsel their clients not to speak to anyone else about the facts of their case, because then that person can be called as a witness. So this argument that conversations from prison by a detainee with quote unquote potential witnesses is a specious argument. That is not something that defense counsel would ever advise their clients to do, because their conversations with anyone other their attorney or someone in the counsel's team of defense makes that discoverable.
Your Honor, that's not the issue before this court. The issue is the Equal Protection Clause. The issue is
yes, you keep saying that, but you're saying that having a conversation with a layperson, not an attorney, not someone from the attorney's team, somehow is violative of the detainee's rights. He has a right to not make that phone call and have his call recorded.
Your Honor, the issue is if Mr. Jennings was not detained, he could have had this conversation without the trial ADA being able to harvest it and use it against him.
And that's true. That is true. But I think we have to look at the fact that that is not a protected class that would be viewed with strict scrutiny. And then you have to look to see whether or not there would be a rational basis for it. And I don't know that that is a legitimate, it's not a legitimate government purpose. Obviously, they say the legitimate government purpose for having this is security and everything else. So I don't know that then you can get to the point where, well, there's also a legitimate purpose where the defendant would have to exercise his right to prepare for trial. And that he's precluded in some way because he can't talk to relatives. It would be one thing, as my colleague already said, be one thing if you were talking about the defense attorney, but there are ways to get to your relatives without speaking to them directly. So anyway, let's hear from
Your Honor, if I just may respond to your rational basis argument.
Yes, of course.
Very briefly, I'm sorry. I just want to point out the fact that there needs to be some rational basis by the state if we're going to say that this is not subject to strict scrutiny, which obviously I submit it is subject to strict scrutiny because of the fundamental right to be able to discuss your defense, discuss your situation, discuss, let's say this was a plea, discuss whether you should take a plea. All of these things are conversations that a defendant should be able to speak about without it being overheard and harvested by the government. Even under a rational basis review, which again, I don't concede, there's no rational basis when DOC has the policy and that's already been established to record an inmate's calls. What is the rational basis for the prosecutor's office to be able to harvest all of those calls? They are not charged to protect the safety and security of docs. There's no actual reason, compelling reason for that. Sorry, Arno, were you going to ask me a question? I believe you're
muted.
I had a question. As I understand your equal protection argument, and you'll correct me, I'm sure, a non-incarcerated defendant, in order to have their telephone conversations recorded and used, there would have to be a warrant that would be issued by a judge to record those conversations because they have a privacy interest in those conversations. That's the basis. In this instance, the defendant is incarcerated. They have consented to the recording of their conversations. They have consented to those conversations being listened to by authorities. So they have no privacy interest. So to me, there is no equal protection argument because of that difference.
You're going to submit that when we look at the recordings, what's told to a defendant, an incarcerated person, when they pick up the phone, as is in the exhibit in this case, is just that your call will be monitored and recorded. It does not say that once you say anything on that phone call, any government official has authority to get it. Without
well, let's just say it said that. Let's say they changed their.
That's the circumstance we have here. And what basis, Your Honor, would there be for any government official to get it?
But you don't need that if you have no privacy interest. If you have no privacy interest, anybody can use the call.
Your Honor, the point is the only reason they're recorded is because of safety and security. So we can't go circular, right? The only reason a conversation is recorded is because of safety and security. Once you get past the safety and security motivations for DOC's policy, it doesn't suddenly mean that any government official could hear these phone calls. And that's the problem here we have. It's disparate treatment of similarly situated defendants simply based on where they're sitting while they're pending trial. Thank you. I'll wait for everybody.
Thank you. Ms. Axelrod?
Good afternoon, Your Honors. I mean, this equal protection clause.
So I just want to ask you that, where we just ended up. So this is for the safety and security. That's how we get after the rational basis test. It's for the safety and security, a governmental interest. But what's the basis then that the prosecutor's office can get that information to increase charges, to add to whatever it is, to use it to prosecute?
Once the defendant consents to the recording, he loses all privacy interest in that telephone call. Whatever the basis for that recording is, this ultimate product of it, which is the conversation, is no longer protected.
Does it make a difference that he's not told this is going to be used for the further prosecution, and that he's told simply that, I don't know, somebody's, whatever the language is, that it is?
Well, two things to that. One is that the Court of Appeals didn't find the absence of a notice that the conversation may be given to be prohibitive. The second thing is, after several cases in the Court of Appeals, DOC has been working towards adding on language that says, and these conversations may be disseminated to government offices. So that should have been implemented already, but that is something that is definitely something that is going forward. But either way, once a defendant loses the right of privacy in his statements, he loses the right to say where they go. DOC, there is an internal administrative code that mandates that DOC provide these conversations upon a subpoena. And because these conversations may contain evidence or threats to witnesses, the people have a legitimate basis to listen to them to determine, one, if there's evidence, or two, if there's threats. The other thing is defense counsel keeps talking about similarly situated between incarcerated and non-incarcerated defendants. When a defendant is incarcerated, he only maintains his constitutional rights up until the point where that is, as long as it is consistent with his incarceration. Once you become an incarcerated defendant, the application of the Constitution and basically your daily life changes in a way that is completely attached to the fact that you are a prisoner. So to say, well, they're the same, except one is in jail. Well, yes, one is in jail, and that means the protections that he operates under are just, and as the U.S. Supreme Court has said and the Court of Appeals has said, they're different and they're limited. So to say that they're similarly situated, I submit, is not an argument that can work in this case. The other issue is, even with that, the defendant still has to show that he's a part of a suspect classification. And no court that I'm aware of has said that by the factor of being incarcerated, you are in a suspect class. That classification would become so broad and so overwhelming that it would sort of collapse into itself. So you don't have a suspect classification. You don't have similarly situated people that they can weigh against. And so that knocks out most of the underpinnings of their equal protection claim. In terms of their ability to prepare for their defenses, the court has recognized their conversations with their attorneys are privileged. They're not recorded. I am aware of the Daily News article about the 1,000 calls that were intercepted, which is, there's no excuse for that, and I'm not making one, but I do understand that everybody's been working to clear that up, and that was only 400 defendants. And this defendant never said any of his conversations were manufactured, or I'm sorry, were recorded. And the great irony of this is that while the defense counsel keeps talking about the need to allow the defendant to participate in his defense, he was explaining why he stabbed his common law girlfriend and sliced her face into ribbons. And that's the conversation that we used, and that conversation was evidence. I can continue talking, but unless the court has any further, I will rest on my brief. Thank you.
Thank you. Ms. Pathmanathan, or
Pathmanathan, Your Honor.
Pathmanathan.
I just want to point this court to Cooper versus Morin, which is the 1979 case in the Court of Appeals. And the quote is that the only legitimate purpose for pretrial detention is to assure the presence of the detainee for trial. And therefore, when anything impacts fundamental rights, we must look at whether it's both reasonable and necessary to the maintenance of security. And when we're looking at that, that is why I believe the DOC's policy of recording calls may have been upheld. But that should not mean that any government agent that asks for these calls without any limitation from a court should automatically get the recordings, all of the recordings. I mean, it is a harvesting of a person's, I submit, private conversations with another about the circumstances of this case. As my adversary has pointed out, he was clearly talking about the facts of this case, his mental state, what was going on, how he acted.
It's not a private conversation. He's consented to it being recorded.
What I mean by private, Your Honor, is not in the legal sense, but in the sense that he's having a conversation with a confidant. And that's clearly something that a person who's not detained would be able to do.
We have to talk in the legal sense. We can't ignore the, I mean, that's what we're talking, we're here to talk about the law.
Let me use the word confidant. He's talking with a confidant. He's talking with someone that he trusts that's not his attorney, that's not in the court of law. And that's something that a non-detained
He still doesn't change, that doesn't change the legal status of the conversation. He still has no privacy interest in that conversation. You can listen to your child's conversation because you're not part of the government. I just lost everybody on my screen.
Well, we didn't lose you, so it's okay.
Okay, well, that's good.
Your Honor, just the point being that at the end of the day, there's disparate treatment between similarly situated people. And all of these arguments about what Mr. Jennings may have known or what DOC does for safety and security doesn't actually address how the prosecutor's offices are able to treat pretrial defendants differently. And if I may point out, the only reason that there's people incarcerated behind bars versus others that are not, for a lot of people, is based on indigency. It's based on the status of their case.
That's not the problem here, though. With your client, that was not the problem.
But the
He
problem
committed a savage attack on the mother of his child, almost having her eye hanging out of her face. So in his case, it would not have mattered because there's no way that he was going to get ROR'd on those facts.
The point being, Your Honor, regardless of the facts of the case, which we're not disputing, every single person has a right to equal protection under the law. It's a constitutional right. It should be protected. It should not be infringed upon by the government, by the prosecutor's office in this case. And for those reasons, this call should have been precluded from Mr. Jennings' trial based on counsel's arguments below on the equal protection claim itself. And he should be ordered a new trial. Thank you.
Thank you. Thank you both. HM against the City of New York. Mr. Becker.
Yes, good afternoon, Your Honor, Your Honors. May it please the court. My office represents defendant, appellate, respondent, Leakin Watts, and defendant, respondent, City of New York. It's conceded by all the parties that New York City Administration for Children's Services, New York City Department of Social Services, Department of General Services, Frankie Butler, and Leakin Watts Association of New York City were properly dismissed from this case. For the sake of brevity, I'm not going to spend a lot of time going over all the facts. There are a few that I do.
That's a good idea. You should just get right to it. I think we're pretty familiar, except maybe one. Okay. Was the child burned in a bathtub with bath water in it, or in a bathtub with the shower?
It was a bathtub with the shower on.
With the shower on. Okay.
Yes.
How were the inspectors or detectives or whoever it was who came, how were they able to test the water, temperature? What water were they testing?
Okay, so they weren't sure. What they did, though, was they took a...
No. They weren't sure about the temperature, but they were sure about what they tested. That's my question. What did they test?
So they didn't, what they said was that they thought that they turned on the faucet to the tub and filled up a jar that they found in the house. They weren't sure whether they took the water from the shower head or from the faucet. They didn't know that answer.
Okay.
That was unclear.
But it wasn't water that existed sitting in the tub.
That's correct. They ran the water, they let it get hot, then they put a bucket under there or some sort of dish, a plastic dish they found in the house. They filled that up and stuck a thermometer in it. That's what they did.
Okay, thank you.
All right. But I wanted to go back to a couple
I
of...
have one question
Sure.
before you proceed. Was she burned with water from the shower, or was there water in the bathtub?
So she got burned by the water from the shower head. That's clear. She was wearing a diaper at the time. And so the diaper soaked up with the water that was coming down on her. She was wearing, she didn't...
So you mean the water that was coming down on her wasn't hot enough to burn her? It was only when it accumulated in the diaper?
Listen, we're taking some assumptions there, but yeah, that's the understanding.
I mean, I'm just based on what you said then,
Right.
but as I understand it, her back wasn't burned. It was her buttocks that was burned and needed a skin graft.
That's correct.
Okay.
Okay, so the how that burn happened is a little unclear in terms of how the water came. Yeah, so we don't know if it was because the water had wet her diaper and was exposed to her skin, or there was some sort of...
In any case, Ms. Butler was not found criminally liable or anything like that. It was a momentary lapse, a momentary inattention. So why don't you go from there?
Okay, so I just want to go back a little bit. Back before the incident ever occurred, right? The infant plaintiff's family was being investigated by Child Protective Services. Before the infant plaintiff and her siblings ever even came to be put into foster care, Frankie Butler had already been approved and had acted as a foster parent for years, and she had the ability to accommodate up to 6 children. That was the approval process. Everything was done before these children ever even got into foster care to begin with. I just want to make that fact very clear, because what had happened during the briefs was that the plaintiff's attorney seemed to argue that the number of children that she was permitted to foster was less than what she was actually allowed to address. I addressed this in the papers.
Six children under a certain age seems like a lot, even for the best of caretakers. I must say.
Well, I can appreciate that, but people have 6 children all the time.
Not all of them under the age of 5.
That's true, but there's no restriction on that issue. 0. There's no prohibition of having 6 children in her care. Now, I also want to get to another issue with this sort of concern. At the time
and you should move along, because you had 5 minutes and we're over it, but I understand you were interrupted, so I'll give you a few minutes more, but you should move along.
Okay, so the issue in terms of the number of children have no bearing on the actual incident that occurred. There's 0 testimony, 0 evidence that any of the other children had anything to do with Frankie Butler's inattention.
Can you tell me, other than the buttocks, was this child burned anywhere else? It doesn't make sense to me how she gets burned in what is being described as scalding water, but her feet are not burned. How does that happen?
So she got, as soon as this occurred, she got yanked out of the tub, right? And it took a little time to get the diaper off. So the diaper was wet, and there's chemicals in diapers as well. We don't have the specifics in terms of what caused those injuries, a combination of what was contained in the diaper and you
have an affidavit from the plaintiff's expert detailing the amount of time that it takes if the temperature is, if the water is at 120 degrees, a burn would occur after 5 minutes. If it's 130 degrees, a burn would occur after 30 seconds. If it's 140 degrees, will occur after 5 seconds.
Right. So the delay in terms of why that burn may have occurred in the specific area was because she was wearing a diaper, it got wet, it got soaked with the hot water, and it took time to get her out of the tub and then into another room where she was where the diaper was then removed. So that's the timing factor of why the burns were prominent in the area that they were. So in terms of some of the arguments, right? Frankie Butler, it's very clear that it was her negligence that caused this issue. It was truly the sole proximate cause of this incident that occurred. She looked the other way while this baby went into the tub, and she had turned on the hot water to the entire hot water position and allowed the hot water to come out without regulating it. Now there's case after case. The Zeitley case in particular is very much in line with these facts, which show that the proximate cause was not anything but the parents' negligence in supervising the child. Now,
Are there any other questions from the bench? I just want to find out. Okay, I'm going to move on because we've given you quite a lot of time. All right, on to Mr. Delicarpini.
Yes, good afternoon, Your Honors. Christopher Delicarpini for the Miller family. We've spent a lot of time on causation already. I'm happy to answer
I just want you to address any cross appeal you have as well. I want all parties.
Certainly, absolutely. I'm going to start with the issue of governmental immunity, which has not come up yet. The city argued below that it has no duty to the children it places in foster care. In the Sean M. decision, which we cite, this court held there is a statutory duty to the children the city places in foster care. This court cited the Second Department decision in Barnes, which cited multiple sections of the social services law. And as this court said in Sean M., when you have a statutory duty, there's no need to prove a special duty or a special relationship. The city recognizes the import of Sean M.
This seems like there was a momentary, I think, as it's been alleged, momentary inattention. Is the city responsible for that?
That gets into the proximate cause issue. I'm happy to address that, Your Honor. Yes, it does. And I want to correct something Mr. Becker said. I'm going to read from the record at page 699 to 700. This is the deposition of Ms. Simmons from Leak and Watts. She confirms that their last reauthorization for Ms. Butler before this incident said, and I'm going to quote, future placements should remain as 5 girls and/or boys for this reauthorization period unless changed by agency. I'm not sure what Mr. Becker was referring to when he gave contrary facts. That's what I see in the record. So with that in mind, Leak and Watts recommended she have no more than 5. They knew she already had 2 when they gave her the 4 Miller children. And I submit it is an issue of fact whether a mother of 6 children under the age of 6.
Yes, but she said that it was she didn't say that she was distracted because she ran after other children. She said she was distracted by, I think she turned to put her clothes, the child's clothes somewhere, and then when she turned back, so that's not, that's inapplicable.
I think it's,
that's why I'm saying it's a momentary inattention, based on what the facts that we've been given.
Your Honor, the facts are we have 6 children under the age of 6 at home.
But it doesn't matter if that was not what her attention went to. Wouldn't matter if the place was filled and they were having a party. She said that wasn't it. She had changed the child's clothing and she went to put the clothing aside. That's what she says. That's what's been accepted. I haven't heard any or read anything that challenges that. And so that doesn't matter what was going on in the apartment if she says that's not what she was distracted by.
She does say what she was doing at the time. That's right, Your Honor. She doesn't say either way what the other children were doing at that time. But we do know there were 6 children under the age of 6 in that home.
Okay, let's move on to something else because you're just speculating. We can only say that she said her attention was turned to that. Okay, put the clothes over. What's your other argument? You argued special duty already.
That's right. There is a government, there is Sean M. I think is still good law. The city doesn't make an argument against that. They say it was implicitly overruled by the McLean decision. Their only authority for that proposition is a line of dicta from a trial court decision, Avila versus State, which actually denied the state's motion to dismiss in that case. Sean M. is still good law. The city does have a duty here. like to speak to the issue of proximate cause as to Mr. Alessia. Justice Martin got this right below when he saw there was an issue of fact as to whether the hot water contributed to this scalding. Mr. Alessia testified he had this installed. He never checked the temperature. We know from the police who checked the temperature, it was 129.4 degrees. And we know from the affidavit of our expert, Mr. Fine, that under the applicable code, which Mr. Schwalge never cited, the defendant's expert, it had to be less than 120 degrees or less at the spout. And that gets into a point I'd like to say about Mr. Schwalge's argument. He doesn't make a prima facie case for non-negligence here because he never says what edition of the code governed. How can you give an opinion on negligence if you don't say what the standard was? Other issues I would like to bring up. The city below, now the defendants want to say that this is entirely the fault of the foster mother. She is the sole proximate cause. That is an argument the city and Leek and Watts and really Alessia did not make below. If you look at their papers, they made arguments about immunity, about statutory immunity, about their own causal effect or whether they had notice. They did not throw Ms. Buntler under the bus below at all. Now they want to do that. I think they should be stopped from doing that because they did not make this argument in their motion papers below. That's it, unless there are any questions.
Thank you. Let's go to, is it Kelly Wright?
Yes, it is. Thank you, Your Honors. Good afternoon. May it please the court. Kelly Wright from Scahill Law Group for defendant, respondent, appellant Jose Alessia. Just starting where Mr. Della Carpini left off, we absolutely did argue in our underlying papers and cited several times and in all of the papers that it's the end user who's responsible for regulating bathwater temperatures for an appropriate level for a child. And that's really the main thrust of our argument on the appeal. This was an out of possession landlord who was at all relevant times out of possession. He was never notified of any problems with the hot water temperature. We had a seasoned foster mother who had numerous children bathed on a daily basis. There was never a complaint made about any issues with the hot water heater or the temperature. And he wasn't there. He wasn't the one supervising the child or adjusting the knob.
Frankly, I'm wondering on these facts how Mr. Alessia is responsible, and obviously others can answer one rebuttal, when we're just hearing that the water from the shower was coming down on this child's back. The back is, as far as I know, is not burned, and her buttocks is burned, but only because the water accumulated in the diaper and she couldn't get the diaper off in time. So that means what was happening to the water that was coming down on her back? That wasn't scalding? If not, then why is Mr. Alessia in here with this argument that the water was too hot?
I think that's an excellent point, Your Honor, and it goes to the question of how hot was this water really, and was that in any way the temperature of the water the proximate cause of the incident? And we submit certainly that it was not. I just want to point out a couple of other things. There's appeared to be some confusion in the record and the underlying papers. Just to make it clear for the record, there was no repair, renovation, or alteration at any time during my client's ownership of the home to that upstairs bathroom. There was a replacement of a hot water heater on the first floor of the house, about a year prior to the incident. Despite how it was characterized in the record, we've got photographs and evidence in the record that that hot water heater did in fact have a regulator, that it was set to the third lowest setting of 6. So I think the record amply demonstrates that this was an incident that was caused solely by, as it's been portrayed, the momentary inattention of the foster mother. The house was in good condition. There's no indication of any defect. It was inspected numerous times and nothing was identified. And there was specifically no issues with respect to the temperature of the water or the shower installation in question at any point prior to the incident.
Do you have a cross appeal?
Do we have a cross appeal? No, yes. Because our motion was denied.
Okay, thank you. We're back to you, Mr. Becker.
Yeah, so I'll do this very quickly. There's a few points that I do want to make. The rest of the arguments in terms of negligence against the city or Leek and Watts, really just like the number of children, and I'm not going to get into that issue and go back and forth and show in the record exactly where it points us out because that's in my brief, but all of the issues that they're raising in terms of negligence, Frankie Butler's criminal past, whether that was her training, all of that is so well covered and so addressed in detail and those issues are completely irrelevant to actually how this incident occurred. And they're just not relevant, the arguments that are put forth in terms of negligence. Now, when it comes to the issues of the city and whether or not there's governmental immunity, it's very clear that McLean overrules the issue that they're talking about. That's all addressed very detailed in my papers. But the truth of the matter is we don't even have to address those issues if the sole proximate cause of this accident was Frankie Butler's negligence. The next thing that I want to say, and I just want to get this out, is that the issues that are being claimed that weren't argued in the lower court were argued in the lower court. In fact, the position about wanting to look at the memorandum of law, be my guest, look at our memorandum of law, but certainly plaintiff's counsel could have submitted the memorandum of law. In fact, we had a conversation about this. It was very collaborative on what the record was going to look like. Certainly, the plaintiff could have supplemented the record and included the memorandums of law that were submitted in the underlying case. Neither his nor mine were in the record.
Thank you. Let's hear from Mr. Della Carpini.
Thank you, Justice Renwick. I'd like to point the court's attention to page 784 of the record. This is from the deposition of Ms. Butler. Question: that particular day, at the time you start running the water before the incident occurred, tell me, where did the water come out? Answer: out of the spout into the tub. I hope that clarifies the issue of how this child sustained these horrific injuries, where she sustained them.
No, it doesn't. At least not for me. Well, out of the spout into the tub. What are you trying to say? Say what you mean.
It's not coming out of the shower head, according to Ms. Butler.
Okay, out of the spout. Spout is a generic term. It could be the shower spout. It could be the tub spout. I don't know which one we're talking about. But
if we are parsing the transcript that closely, this case has issues of fact. This is not appropriate for summary judgment.
Well, you're the one who brought it up. The testimony says shower. Everyone said shower until you just said something else for the first time now.
I didn't say it. Ms. Butler said it at her deposition. I'm just reading the deposition.
Shower.
I'll say it again, page 784.
No, wait, I'm asking you a question, sir. Would you listen to me, please? Ms. Butler also said shower. Are you saying that then at this page 784, she said spout?
Yes.
And if she did, then shower would clarify spout because she already said shower. Thank you. Is that all you have?
Unless there are any questions, Your Honor.
Thank you very much. Thank you all.
Thank you.
Thank you.
Capon and Associates versus Herskovitz.
Yes, Your Honor. Michael Giordano for the appellant. This is the appellant's appeal of an order from the Supreme Court, New York County. It's an action to recover a brokerage commission on the sale of an 11-building project in the Bronx. In essence, I'll be brief. The order was wrongly decided because the court held that the broker, the plaintiff appellant, Capon, was not the procuring cause of the transaction of the sale. I think what they said.
So then I'm going to ask you to distinguish this case from the RMB case, where the court there found that there was no procuring cause, and the Molly Ann case as well.
Well, this case is different because of all the extensive efforts that were undertaken by the appellant.
There were extensive efforts there too, apparently.
Well, and I will also say that the efforts that were undertaken by appellant were the same efforts that were appropriated by the broker that was actually used to consummate the transaction. So if the court is saying that, the Supreme Court is saying that those same efforts constitute the procuring cause when the new broker does it, well, then they're the same. It's the same as when the old broker does it, the original broker.
I haven't heard you distinguish the cases I mentioned yet.
Well, I'm not familiar with, with all of the factors off the top of my head, I have to be honest, Your Honor. But I will just say that if you look at what they have done, these efforts are extensive and they would qualify as being the procuring cause. And if they're not the procuring cause, then the new broker wasn't the procuring cause either. It's the same thing. All the respondents did was take a deal that was brokered by the appellant and take it over to a new broker so that they could evade the
So I
commission.
just want to tell you, I'm going to tell you the facts in RMB and in Mollian are very much the same, but there they gave the buyer a tour of the property. They forwarded the buyer information. They provided the buyer advice about how to successfully complete a deal. And they actually submitted an offer on the buyer's behalf, which was rejected. So that sounds like more than this case.
Well, I would say that it's less because they also gave the respondents the lowest price that the seller was willing to accept. This was not public information. It was part of a deal that the appellant had previously negotiated. So he was provided with crucial
Did your
information.
client ever communicate an offer on behalf of the defendant here?
They did not communicate the offer only because the.
So then how can they be the procuring agent? They never even extended an offer to the sellers on behalf of your client. There was a lot of negotiating going back and forth, but it never ended up in a deal that was communicated to the sellers.
But that's only because the respondents went around their back, took the same deal that was brokered, and went to a different broker to get a lower commission. That's the only reason why they did not submit an offer. They had all the
we have cases, as I just told you, where an offer was submitted. It was rejected, but an offer was submitted, and that there was no procuring clause there. So in any case, I think we have the facts. Let's go on to your position, I should say, and you have rebuttal, Mr. Lynn.
Thank you very much, Your Honors. At the end of the day, Justice Scarpulla's order should be affirmed because appellant's own admissions and the documentary evidence demonstrated that appellant, each of its 4 claims failed as a matter of law.
What about the inconsistencies between the Herskovitz affidavit and his deposition? Is that something we should be giving weight to and paying attention to?
No, that doesn't change the outcome in the lower court at all for a couple of reasons. First, even accepting everything that that appellant says is true with respect to Mr. Herskovitz's affidavit, Justice Scarpulla didn't rely on it in reaching her decision. She expressly said that her decision was based on appellant's admissions in their deposition testimony and the documentary evidence that was submitted. But in any event, there wasn't actually any inconsistency between the affidavit and the deposition. While appellant wants to cite a bunch of times that Mr. Herskovitz said, I don't know, or I don't recall, Justice Scarpulla recognized that Mr. Herskovitz was able to outline the particulars, the general outline of the transaction, and he corroborated testimony from appellant's broker, specific testimony, including the amount of the sale, the general nature of it, that it was a net purchase, and that the reason the deal terminated with appellant was because they told him that the properties were no longer available to purchase. So this really goes into the assertion that my adversary just made, which is that we tried to go around them and behind their back to get a lower commission. That's just not supported by the record. In fact, if you look at page, the record very clearly shows that on December 13th of 2013, appellant's broker sent Mr. Herskovitz an email saying that the properties are in contract. And she clarified at her deposition that she meant that they could not be purchased anymore. They were no longer available. And before that, Rosewood had reached out and said, are you interested in these properties? And Mr. Herskovitz said, no, I've actually already looked at them and they're not for me. And it wasn't until
after Ms. Benoliahu, after Ms. Benoliahu said they were no longer available, did Capon ever negotiate anything with Mr. Herskovitz again?
With respect to this transaction, no. But notably, if you look at pages 766 and 767 of the record, only 6 minutes after telling Mr. Herskovitz that the properties weren't available, they then launch into a brand new transaction that they want to try and get him on the hook for. They say, here's another 2-building package. We think you should go and take a look and put an offer in. That's 6 minutes after saying the old 11-building package that's the subject of this action couldn't be purchased. So this deal's already dead in their mind. They had walked away, cut it loose, and abandoned the transaction completely. So there's absolutely no basis to say they're procuring cause.
Thank you. We're back to you, Mr. Giordano.
Yes, I just want to address one point. He's saying that the deal was abandoned. They view the deal as dead. They were going on the information that the seller provided to them. It was the
But
seller.
it doesn't matter. But they said, that is what they said. They said it's no, he asked them, they said it's no longer available. Too late, sorry, no longer available. What does that mean? And then they never followed up with that again. They never called him to say it was on the table again. They said it was no longer available, and then they didn't negotiate anything with him.
Well, with respect to that, Your Honor, that's because he never called them. They were going on the information they had. So in their minds, yes.
Why would he call them if they already said it's no longer available?
But that didn't stop him from calling Rosewood. He still reached out. He was still looking to buy the properties. Instead of calling a different broker and taking the same deal over to them, he should have called Kaplan and asked.
I don't think there's anything that bound him at that point, because there was no offer. There was no offer made by.
Only because he was looking to pay a lower commission to Rosewood. If he wanted to buy the properties, he couldn't just abandon them and walk away after accepting all of their work. He was obligated at that point, if he wanted to pursue it with the broker that actually brokered the transaction.
Did he call Rosewood, or did Rosewood call him?
He called Rosewood.
He called Rosewood. That's what the facts. That's what the record states.
Your Honor, yes.
So I read something different. I read that Rosewood contacted him in January and said, "The package is back on the table. Are you interested?"
My understanding was that the record shows that he contacted Rosewood after he was told that the deal was closed. Rosewood had contacted him back in December. He was already talking to Rosewood in December, even before this information was miscommunicated by the seller. So he was already in contact with this other broker, even while he was dealing with Kaplan, again, because the commission was be lower.
Thank you. Thank you both.
Thank you, Your Honor.
PD versus LaCour-Guyette.
Good afternoon, Your Honors. My name's Alan Friedberg. I'm with Wilson Elser. I represent Montefiore Medical Center. Dr. Guyette was let out right after jury selection. He was the surgeon who originally operated on the child, as you may know from reviewing the briefs, where the child had a potentially deadly heart condition that he fixed on the morning of June 27th.
Mr. Friedberg, I want to ask you, is the first surgery relevant to the second surgery? I mean, in terms of proximate cause? Wasn't the first surgery?
In no way. And that's my first major argument. In this case, this is the verdict sheet. The verdict sheet expressly states was the second surgical procedure on June 27th.
Excuse me, how did the needle get into the child if the surgery is not relevant?
Because it was already decided by this court that it was a departure to leave the needle in and send the child back to the PICU with the needle in. This court, Judge Rubel, decided it in the lower court, and then this court decided the same thing. That is that the negligence was no longer an issue. It was negligent to leave the needle in. The issue is, did the second procedure that was required by the needle being left in cause any injury?
And was it limited to that? Was that the question that it was limited to? I'm presuming it was because of the verdict sheet. There was only one question on the verdict sheet.
Only one question other than damages. Here it is. It says, was the second surgery a proximate cause of injury? Was the second
question there was with regard to whether the child was sedated. Was the issue? Was whether the child was given sedation or not?
There was a lot of testimony going back and forth as to whether the child was sedated. The child received propofol, and if any of you have ever had a colonoscopy, you know that if you get propofol, it causes amnesia and a lack of pain. And yet the plaintiff's argument is that this child who was on propofol,
Sir, it doesn't always cause amnesia.
But in any case, it knocks you out. But that's the question.
It does when it's combined with Versed and ketamine, which this child received 3 medications. And in any event, that goes to the issue of damages. But my argument is, for purposes of reversal, that there was extensive testimony regarding the departures in this case. Plaintiff's counsel called 4 witnesses. Of the 6 witnesses that he called, 4 witnesses testified either exclusively or primarily on the issue of the departures. the needle falling on the floor, not looking for it, not using a roller, not doing intraoperative x-rays, not doing a proper instrument count. And I can tell you, this is the first argument I've ever made before this court in appeal. I mostly spend my time as a trial lawyer.
Counsel?
Most of the time.
Somebody, excuse me, just a minute. I believe that somebody has their mic open. If there's any lawyer here that has a mic open, please turn it off. I'm sorry, go ahead.
Was there any objection, counsel? Was there any objection by defense counsel to all of this evidence being brought in?
Right here, Your Honor. Page 63 and 64, PDF, page 66. We made a motion in limine to preclude the testimony of the nurse and the technician with regard to what occurred in the operating room. I direct your attention to that. And Mr. Moranis, the defense counsel, said we continue to voice an objection to any instructions with regard, meaning introductions of evidence with regard to departures. And the court said, stop them, said stop. Okay, here's the thing. If you don't call the witnesses, you don't bring the witnesses in, I'm ordering a so-ordered subpoena to bring those witnesses in. You're going to have the departure testimony before this jury, and you have an exception. There is no question that we reserved it. And frankly, the case law is clear.
So, Mr. Freeberg, I have a question. Are you saying that once a summary judgment motion is granted on liability, then the plaintiff basically waives their ability and right to paint the picture and tell the story to the jury so that they have context of the instant action? Is that what you're arguing?
Exactly, Your Honor. In this case, the jury was prejudiced. So
plaintiffs should not be moving for summary judgment lest they are stopped from being able to tell their client's story.
Well, no, because
is then the message from this case.
Well, they move for summary judgment on both departure and proximate cause. As a matter of fact, the original decision was to dismiss the case on proximate cause, but that was reversed. But the question of departure was granted. And Judge, I want to make this point. I've argued many cases before juries, and every plaintiff's attorney invariably says, we're not trying to say this is a bad hospital. We're not trying to say it's a bad doctor. It's just in this case, they screwed up. And in fact, and this is just the opposite. Here, the plaintiff's attorney with the defense attorney's hands were tied because as a matter of law, it had been decided that there was a departure. This plaintiff's attorney called 4 witnesses and gave extensive testimony with regard to the nurses and the doctors and
I want to just address that issue because you said that already. With regard to whether or not this means that you can never talk about summary judgment. Summary judgment is a decision on law. It's as a matter of law. So it doesn't have to come into the other case unless it's relevant to something. In this particular case, this second surgery, the question I thought as I read the record was that there has to be a second surgery because this needle is in there. That's kind of obvious to the jury that there's a needle there when the case begins. But that I'm sorry, I lost my train of thought. But that there has to be a second surgery, but the issue was the sedation. I thought that was the sole issue with regard to the second trial.
Judge, 4 witnesses testified about the departures in the first surgery.
That's not what I'm asking you about. I understand that the 4 witnesses talked about the departure in the first surgery. That whether or not that should have happened, that's a separate issue. That's the question is with regard to the second surgery, what was the issue? Your argument here is those 4 witnesses should never have been able to testify. That was with regard to the first surgery, which was not implicated in the second surgery. The question in the second surgery was there something that happened there that led to damages? I mean, what the plaintiff is saying is they didn't sedate my child. So my child has these emotional scars. Was that the issue at the second trial? I keep saying trial. Second surgery, or was it something else?
That is the issue on the second surgery. Yes, you have it right, Judge.
So then there was no
question on the
as to
verdict
whether
sheet?
or not, can I just finish my question? So that there was no issue in the second, I understand that you had an objection to it, but the issue at the second trial was not supposed to be about the first trial that summary judgment was requested and decided upon. Am I correct?
And you're saying trial, I think you mean surgery.
I mean, first
But yes,
surgery that
the answer is yes. The first surgery was irrelevant to this case. It was
Then why
irrelevant.
did you open your argument here by saying that the first surgery saved the child's life?
Because, Judge, during the motion, that was made.
Papers down. We don't have papers here.
Okay. During the motion, Judge, to preclude the evidence of the first trial, the court made it clear it was going to allow all the evidence of the first surgery, and a decision had to be made from a trial perspective about the first surgery. And so the lawyer opened up on the fact that the surgery saved the child's life. Because that's what it did. It didn't go into the departures. The defense attorney's opening didn't go into the departures or how there weren't any departures, because it's conceded. It's a matter of law. We couldn't argue that there were no departures. You had already made that decision. There was a departure that caused the second surgery. You made that decision. How is it relevant to the jury? As a matter of fact, it inflamed the jury. 6 pages of the plaintiff's summation had to do with the departures that were already decided by you and by Judge LaBelle. So as a matter of fact, what happens is when the jury has to focus on the second surgery, and as Judge Renwick rightly pointed out, what occurred during the second surgery, they were prejudiced by already looking at this hospital as a shabby hospital who belies imagination. The summation said it belies imagination that this could have occurred.
Mr. Friedberg, I have one question. The jury verdict sheet, did it specifically ask a question about whether the child was sedated or not?
No.
So there was no question to the jury about sedation?
No. The only claim was, did the second surgery, was it a substantial factor in causing injury? And I don't want to show it to you because I don't want to get Judge Mazzarelli mad that I'm showing you papers.
I mean, I wouldn't get mad that you showed us paper, but truthfully, we can't read it from where you're showing it, so it kind of doesn't help. But
it's page 743 of the record. The PDF is 220 volume 2 PDF. That's the verdict sheet. That's the question. And
that question again is what? I know I can find it. I've seen it.
Was the second surgery on June 27th that defendant performed to remove the needle a substantial factor in causing injury? Plaintiff does not say that the meds were bad. He says the meds were good. He's just saying they weren't effective. That's what the claim is.
Well, if they weren't effective and the effect of the meds, the only meds that were given were sedation. Am I correct?
But there's no claim about that. There's no claim.
I understand, but when they're saying the claim was with whether that the meds were bad, that's another way of saying the meds were not effective. They weren't effective to do what they were supposed to do, which was to sedate. Is that correct?
They were saying, Judge, that what the plaintiff says was that this child could remember the procedure and it had affected him emotionally. That's what they were claiming, that the child could remember the procedure and it affected him emotionally. That's what the claim.
Remember what procedure? I'm not.
The second procedure.
I understand, but what aspect of the second procedure?
That he was cut. The whole procedure, that he was cut, that he was in a room with 5.
Right. Okay. So, Mr. Friedberg, what I'm asking you is, how does somebody remember that they're cut if they are sedated?
Well, because he ultimately, if all you do is look at his chest, he has a 5-inch.
No, but that's not what I'm asking you. In other words, he doesn't remember anything because he actually saw them cutting him. These statements are not coming from that he sees them cutting him. Is that your argument? Your argument is the sedation worked. The sedation was proper. That's what you're saying. Am I correct?
He spent 7 days in a hospital after his chest was cut open. Yes, I'm saying yes, Judge.
Right.
That can affect a child. A 2.5-year-old child will spend 7 days in a hospital after they have a major heart operation and their chest is cut open and they have a tube in their penis and a tube in their arm and a tube in their chest and a tube in their neck and get.
And would that have been the case anyway, even if there wasn't a second surgery?
Anyway, he spent 7 days in the hospital because of the surgery. He had all those tubes in him because of the surgery. He had all the pain medications because of the surgery, where his chest was cracked open. And
that's the first surgery you're talking about.
The first surgery.
The first surgery.
The first surgery, a major surgery to a 2.5-year-old child. If I can get to the second point so I can, because I know I only have 6 minutes. My second point
well,
is—
I've given you over that anyway. As long as we have questions, we'll ask you. But I just want to be clear that you're saying that he didn't spend any extra time in the hospital because of the second surgery.
None, and there was never an allegation to that effect.
Okay, if you get to your second point, then.
Okay, and the second point is that the plaintiff was allowed to testify, or the plaintiff's expert, Dr. Lubit, was allowed to testify about all the things that the plaintiff told him that the child suffered from, the history and the complaints of the child. The plaintiff's expert was allowed to testify to that. And this court, in fact, the law in New York from 1892, in the case of Davidson versus Carell, has held that a non-treating physician or expert cannot testify about what the plaintiff tells them about their history and complaints. It's not only is it Hornbook law, but this court in 2004, with a bench including the Honorable Judge Manzarelli in a case called Cuban versus Kaiba.
It's not Manzarelli, it's Manzanet and Mazzarelli. I don't want you to get in trouble, so I'm just letting you know.
And you can call me Alan Friedman. I apologize.
But we don't want to. So I think you're referring to Justice Mazzarelli.
I am referring to Judge Mazzarelli. Judge Mazzarelli, in 2004, November 2004, you were on a case called Cuban versus Kaibo, in which your bench ruled that holding plaintiff's claims of emotional distress were improperly bolstered by a non-treating psychologist testifying to hearsay about what the complainant told him about complaints and history. And that's exactly what occurred.
Was that a case where the plaintiff ended up committing suicide?
I don't believe so.
It wasn't a psychiatric malpractice case?
No, it was not. It was not. It was a fire case. And in that case, you made it clear that that an expert can't testify about the hearsay statements with regard to the plaintiff. They can review the records, and there were no records here. This infant has never been treated by a psychologist, psychiatrist, social worker, or anyone. This infant has never received a medication of any kind whatsoever. And this is a conscientious mother. Let me say that the plaintiff in this case is not somebody who ignored her child. She got her child into a charter school and is actually working to get the child a good education. But this mother has taken his child to the doctor. No records were introduced by the plaintiff whatsoever to show that this child has any complications whatsoever psychologically from this incident. None whatsoever. No, and yet,
Counselor, isn't there some injury that is cognizable simply by having an unnecessary surgical procedure?
Well, if it happened in the child's bed that night, where he didn't have to be taken out of his bed.
Just don't give me all these other things. I'm asking you a very simple question. If there is a procedure that is unnecessary, and here had the needle not been left in the child, the second surgery wouldn't have been necessitated. Isn't that in and of itself an injury to the child?
And Your Honors, I would say no, because all they did was snip the sutures, pull the needle out. It took 6 minutes. It took 6 minutes. They snipped the sutures, found the broken piece of needle, pulled it out, and closed pre-sternal wound with the chest, with the muscle and the skin back up. That's it. No cut was made. The cut was already there. The only thing that was cut was the sutures. So everything in life affects us all, but that's really not an injury. This child was not injured by that, and that was our position. But the fact of the matter is, the mother was allowed to the expert was allowed to testify about everything the mother told him, and that's clearly from it's in a violation of the law of the state of New York from 1892, including this appellate division. And so our argument is that testimony shouldn't have been allowed. The testimony about the needle being lost.
1892.
Yeah, you better correct that too. When was that case again? 2004, I thought.
November 6, 2004, Your Honor. Judge Mazzarelli, you were on that bench in 2004, a mere 16 and a half years ago.
Okay, I think we better move on to Mr. LeMay, is it?
Is he here?
He went home. No.
Both ways are okay. And I apologize for only being audio.
It's okay.
Unfortunately, I'm not sure I'm dealing with the same case that counsel just described.
Well, was there a needle left in? Was there a piece of a needle, broken part of a needle left in the cavity of the child?
Absolutely.
Okay, so then it's the right case.
Surgery. Okay, that was the first surgery. This court ruled in a prior motion for summary judgment that came up that yes, there was a departure, but no, there cannot be any finding of liability in the medical malpractice case unless and until the plaintiff establishes that that departure resulted in some damage to the plaintiff. Now, that initial departure had to be understood by the jury before.
Counsel, let me ask you something. The initial departure was that there was a piece of a needle in the child. Now, I don't know, but I think if I walked up to anybody on the street, they would not say that a child is born with a piece of needle in the child. And this is a medical malpractice. The jurors know that. They're there. That first issue was as a matter of law. All the judge needed to do was to tell the jury there's a piece of needle as a result of a first surgery. That's it. Now they're going in, and the impact on this child, as I understand it from your papers, is that it suffered emotional distress because it wasn't properly, the child wasn't properly sedated, or there was the second surgery that caused the injury.
Judge. That's only part of it.
I beg your pardon?
That's only part of it.
But what was the other part? Because I'm from the question that was asked on the verdict sheet, it was the second surgery a substantial factor in causing injury?
Yes.
So it's only the second surgery. Why did you need to have anything else?
Well, let me explain. What counsel for defendant leaves out, what they've ignored at trial, what they ignored throughout in all their papers, is the fact that this is a 4.5-year-old at the time, 2.5 years old. But in any event, when the surgery happened, the mother accompanied the child into the prep area for the second surgery. She was told to leave about a half hour, maybe a little more than the second surgery. He was in the room for more than 30 minutes alone with 5 strangers around him, fully conscious, fully awake. None of this is denied. They're wearing strange outfits and masks. And the child is absolutely beside himself, hysterical. That is absolutely part of the damage.
So, wait, I want to make sure that I understand you correctly then. So are you saying that the psychological damage was from what you've just, let me finish, what you've just described, and not a claim that the child was awake during the actual procedure?
No, I'm not saying that. I'm saying that there is damage here resulting from both. From both. The half hour plus 8 o'clock p.m. to 8:30 something when they first started administering sedation through the course of the second surgery to remove the needle. Now, two things. Number one, the mother gave consent only for sedation. By definition, sedation does not render you completely unconscious. That is general anesthesia. And even though they were
Counsel, are you telling me that this child is screaming? I don't know if you have any children, but it's a 2.5-year-old. The child is screaming. I've never seen a 2.5-year-old scream without arms and legs flailing. And under those circumstances, is it under those circumstances that you're telling me they were able to cut this child, the sutures, and take something out and then re-suture the child? That this is a medical procedure and that's the way they did it? Is that what you're saying here? Or are you saying that in a hospital where there are certain protocols that a child can't be left just with the hospital staff? Is that what you're saying? Because I'm completely confused by your argument.
My argument is really very straightforward. First of all, they kicked the mother out and had the kid alone for a half hour because they said they had to.
Counsel, we got that part. Counsel.
But
really?
I'm giving you the reason that they kicked her out. But
what we need to understand and what we need to be real clear on is whether there is a claim that this child had a procedure, was cut, as you say, and he was awake for it.
Let me be 100% clear. The infant was sufficiently aware to know what was happening to him. The hysterical crying, the incredible fear that was evidenced by that crying and the movement that you've described is the half hour plus that he was being prepared for the second surgery. I'm not going to say that he was running around the room like the fastest runner in the world and jerking his arms and jumping up at the ceiling or whatever, and they did surgery. What I'm saying with respect to the actual needle removal procedure was that the infant was sufficiently aware of what was happening to him, that immediately after he came out, he was sufficiently awake and aware to tell his mother 3 times, "They cut me," and to thereafter, as a combination of these circumstances, have a tremendous fear, which, by the way, is fully documented in his school records.
And this just so that I'm clear, when he came out and he was able to tell his mother that they cut me, that's because he was aware of getting cut during the surgery.
Yes, or look, I can only tell you what he said. I can't tell you if that was his impression or he knew, but he stated affirmatively, "They cut me, they cut me, they cut me," and he was scared to death. That's what. Oh, and by the way, one very important point that defendant has said throughout: they only cut the sutures. They didn't do anything. He didn't feel anything. The operative report of Dr. LaCour-Gayette says we had to resuture the presternal muscle. Presternal, I don't know which one it is, but as we finish this needle removal, indicating they obviously cut into that muscle. So this was not just, we just dabbled to cut it through. No, it didn't happen like that.
Wait. Did it happen in 6 minutes or didn't it? And is that not called subcutaneous tissue?
It happened. I wasn't there. They said it was.
Well, you said you read his report. Those kinds of things are in the report as well.
It was 20 to 25 minutes, but he
not for the surgery itself. That's what you're speaking about with regard to the cutting, which the child spoke about. You're saying.
I'm talking about the entire procedure to remove the needle.
No. You just spoke about the cutting, and that's what you were answering the question about the cutting and how the child knows about it. And then you started to go into the process of the cutting.
Well, to me, it's one and the same. The surgery involves a cutting and removal of the needle. Once you cut and you see the needle comes out in a half a second. So 99% of that time period is doing the cutting to get to the needle. But there's a lot more. Look,
anything further, sir?
Yes, yes.
Oh.
I'd like to say that the defendant's attorney made no objection whatsoever to any part of the pre-evidentiary jury instructions, the post-evidentiary jury instructions, the plaintiff's opening statement, or the plaintiff's closing statement. The foundational objection that they say excuses all subsequent failure to object was something that happened in a pre-evidentiary in limine motion.
Was that in limine motion the document in writing that objected to the evidence that was then spoken about and raised in opening, in closing, and in cross-examination or direct of the witnesses? Was it not subject?
It was a specific application to bar, I think it was 2 nurses that were already under subpoena from being brought in. And the remark that
barring the nurses, if I can ask, are you saying it was barring the nurses because of the testimony they were going to give about the first trial,
that is correct, but
okay. And so the statements then in the opening and the closing and the direct also went to that issue. Is that the case?
Well, the defendant's complaint about the opening and the closing was that the judge put the issue of whether or not there was a departure before the jury for its determination. They didn't object to it. And my point is that, assuming for a moment that the judge did, which we do not agree with, the only party that could possibly be prejudiced were the plaintiffs. They would have had to reprove an issue that had already been decided in their favor by your court. So they were the only way. I mean, what if we had to prove that and we lost? That's the end of the case. I mean, and we cite Cullen versus Naples, an old Court of Appeals case, relatively old, that says the parties can chart their own course. But that's not what happened at this trial.
Yeah, I don't think that's the case law we're talking about relevant to this. But in any case, yes.
Well, what happened at this trial, again, was at all key moments, there was no objection made by defendant's trial attorney. So none of this was preserved. And also, to be specific about the objection that was made at that in limine discussion, the defendant's trial lawyer said, I don't want to reference anything that happened during the first surgery. Well, excuse me, the departure happened during the first surgery.
Except that it didn't impact on the second surgery. The departure was leaving the needle in there. That was, I think, somebody got summary judgment. I guess that was you. Plaintiff got summary judgment on that issue. The needle was there. It was a departure, period.
Yes.
Right.
Yes. But my point is, look, someone had to put an explanation of what the departure was before the jury. Now,
I think that issue was obvious. There was a needle in the child. And as I said before, I don't want to belabor this. It was a medical malpractice case, but that was then a matter of law. The judge could easily have done it.
Well, here's my point with respect to that. And excuse me, I'll lose my voice, but that's no surprise. But my point is this. The defendant's counsel could have said that to the jury. He could have asked the judge to say that to the jury. They didn't.
Counsel, all right, can you move on to your next point? Because I think, can you move on to your next point? Because this point is about the motion in limine still. Can you move on to the next point?
Well, the only point, well, we have our appeal had to do with the reduction in the award of damages from $1 million to $150 for past pain and suffering, and from $1 million to $450 for future pain and suffering. And what we're saying about that is that clearly, the 150 is way under, and the $1 million is supportable. You've got three periods of time. You've got the terror that he suffered for at least a half hour, then the additional terror he suffered during the needle removal procedure. That took an hour. Then you've got the time from that to the time of trial. There was ample evidence as to
the
what
time of
his
trial.
damages-
What? Oh, I see. Okay, sorry.
Ample evidence. And by the way, the point that Dr. Lubitz, the plaintiff's psychiatrist, couldn't testify of what his mother, Tyneka Velda, said to her. How else do you have any evidence in a case like this of what the child suffered? And by the way, the reason that it can be forbidden is that it enhances the claim to have an expert repeat what the party told the expert. Dr. Lubitz, and we quote it in our reply brief, was very clear. He was not endorsing in any way, shape, or form either the credibility of the mother or the truthfulness. He said very specifically, that's not my function. That's the function of the jury to decide whether or not that person, the mother, is telling the truth. So the reason that they don't permit it is not in this case. And by the way, the defendant's attorney had his own psychiatrist testify on the basis of what the mother told him. And at trial, in his questioning, the defendant's trial attorney emphasized how important the clinical interview is. So there's no basis to object on,
Thank
Dr.
you,
Lubitz
counsel.
testified based on what he said. How else can you get that evidence?
Okay, thank you. Mr. Friedberg, we're back to you. You have 2 minutes.
Muted.
Oh, I got to mute.
He's muted.
Yes. But you're muted, Mr. Friedberg. Mr. Friedberg, you're muted.
I hope you won't hold that against me. I apologize.
No, that's a lesser thing than the mispronunciation of.
Judge Manzanet, I know very well. Judge Mazzarelli, I apologize. And let me say that on page 833, it says that the closure began at 8:36. The beginning of the taking out the broken needle started at 8:30. It was a little minor procedure. The fact of the matter is, this child had a Foley catheter in his penis. He had a catheter in his chest, a chest tube in his chest, a catheter, an arterial line in one arm, an IV line in the other. And the claim is he was screaming and yelling. The same mother who testified under oath that this child was intubated from the time of the first surgery to the time of the second surgery, though he was extubated at 11:40 a.m. So let me just say that with regard to the surgery
and the hours between the surgery, we're talking 6 hours or 8 hours or something?
8 hours.
It was the same day.
8 hours. Now, the fact is that the plaintiff's attorney has not addressed the most important issue for us, and that is the irrelevant evidence of this departure, the departures that came in. Under Obregon versus Glebeditz, the third department state case, but most important law in this case, this jury was prejudiced. Plaintiff's counsel went on for 6 pages in the summation of belying the imagination that this could have occurred, to the point where he then asked for $2 million over a 50-year period. And lo and behold, what does the jury do? Award $2 million over a 50-year period for a child who has never received any psychiatric, psychological, social work, or any professional care whatsoever. There's nothing in his school records anywhere that was introduced. There were no records introduced by the plaintiff of any doctor's appointments where the patient was afraid to go to the doctor or had a problem going to the doctor, and it was incumbent upon them to prove it. The only thing they used was the mother's testimony, and then, again, reversible error, they allowed the psychiatrist to testify about the mother's testimony, essentially bolstering that testimony since it was the only evidence, and improperly bolstering it pursuant to the case law I documented before. With regard to preservation, let me just say there's one other old case. It's called Schultz versus Union Railway. It's 181 New York, not second, not third, 181 New York, 1905. All you got to do is make one objection to the regards to the nature of the evidence, and you preserve your right. We did that not just by making the argument, but by making it in writing, by putting it on the record, being cut off by the judge, and then when the judge gave the charges and talked about negligence because he was using a form charge, he just confused the jury. But the fact is, the verdict sheet exemplifies the reason why this was prejudicial. The only question, okay.
If you just wrap up your sentence, the only question, end the sentence.
The only question is, should the evidence of a departure and bolstering be allowed, and did that harm the defendants? Absolutely. Thank you very much.
Thank you. Thank you both, Mr. Lame as well. Thank you.
May I have an opportunity to respond, or are we too far
There-
over?
There was no cross appeal here. Am I wrong? Oh, I'm sorry.
No, we
Yes,
have
you
a-
did. Yes, you did have a cross appeal.
Yes. Okay. Let me just say we did address specifically what counsel is talking about as far as this alleged prejudice. There was no objection. The actual reason why the result of the case is what it is that the defendant took a gamble, a huge gamble. They gambled on all or nothing. They told the jury in the opening, this is a happy case. You're one of the luckiest juries. Everything ended up wonderful. They claimed there was no damage, no nothing. Now, as far as the second surgery, again, in and of itself lasted X amount of time. But you have two distinct portions of it, each one of which would have a profound effect, which is all documented. And Dr. Lubitz said, I couldn't give a formal diagnosis because he's the most withdrawn child I've ever seen at that age. He just didn't talk enough for me to give a formal diagnosis. But he said there's a profound effect on his life and it's permanent.
Thank you, Mr.
Thank you very much.
Lame, if I pronounce your name, Mr. Friedberg. Thank you very much. This yes. This concludes oral argument for today. Court is adjourned. Thank you, counsel. Have a good evening.
You too.